Okay, everyone, we're going to start the live stream.
Good morning, everyone. We will go ahead and get started. Thank you for joining the Arizona State Board of Pharmacy meeting. Today is February the 4th. It is 8:30 a.m. And before we get started, I would ask Dr. Gandhi to do a roll call, please.
Thank you, Mr. President. Mr. Solari? Mr. Solari? Mr. Dang?
I'm here.
Mr. Minkus?
Here.
Mr. Leba?
Here.
Ms. Lahan?
Present.
Ms. Walmsley?
Here.
Mr. Tong?
Here.
Mr. Goodman?
Virtually present.
And Ms. Nair?
Here.
For Mr. Solari. Mr. Solari?
Present, sir.
Thank you, sir.
Okay, thank you. Board members, I'd like to give you an opportunity if you have any additional conflicts of interest. I'll just run through the list real quick. Mr. Minkus?
None.
Ms. Lahan?
None.
Ms. Snare?
None.
Ms. Walmsley?
Nothing additional.
Mr. Dang?
None.
Mr. Goodman?
None.
Mr. Solari?
None.
Okay, and I don't have anything additional to add as well. We will pick up with tab 30. Cases recommended for approval of state's motion to vacate hearing and deem allegations in complaint admitted. This is the time for the board to consider consent agenda item 30A through 30K. Matthew Anderson, board case number 20-0334. Fatima Sadeghi, board case number 20-001. Jose Ivan Barrientos Castro, board case number 20-0327. Jaime Leanne Rosser, board case number 20-0357. Kirsten Bailey Purdue, board case number 20-0103. Caitlin Bohazoni Yazi, board case number 20-0380. Joanna Beltran Contreras, board case number 20-0381. Nuhad Yeha, board case number 20-0378. Bailey Renee McMeans, board case number 20-034. Sharon Anne Marie Chloe, board case number 20-0451. Liliana Elaine Rivera, board case number 20-0488. Does any respondent, attorney, or board member want to pull any case from the consent agenda for further consideration?
President
Mr.
Leba.
President. Go ahead,
Seth,
Mr. Hargraves.
Seth Hargraves, Assistant Attorney General. The state would ask that you pull 30D, Jamie Crosser, and 30I, Bailey Renee McMeans.
Okay, thank you.
Mr. President, Jean Galvin, Assistant Attorney General. I just got off the phone with the respondent in case number 30B, Fatima Sadeghi, and it appears that she may be trying to log on.
Ms. Galvin, did you say 30B as in boy?
Yes.
Okay.
Okay, so noted that. We will pull those as well.
I'm sorry, Mr. President, I was on mute, but I did see Fatima Sadeghi log in. She's on our meeting.
Okay.
Hello.
Hi there. So good morning. So Mr. Harris, would you recommend that we move through the other cases, then come back to those?
You're muted.
Sorry about that, Mr. President, members of the board. I would.
Okay, thank you. Will the state's attorneys please introduce themselves?
Seth Hargraves, Assistant Attorney General.
Jean Galvin, Assistant Attorney General.
Are there any other parties present for these matters? Okay. The state has filed a motion to deem and vacate the hearing in each of these matters. If these motions are granted, the board will have adopted the factual allegations set forth in the complaints and its findings of fact and the alleged violations of law as it is conclusion of law. Is there a motion regarding the state's motion to deem?
Yes, Mr. President. I move for the board to grant the motion state to deem and vacate the hearings.
Second.
Okay, I have a motion and I have a second. All those in favor?
Aye.
Aye.
Any,
Aye. Aye.
any opposed? Okay, thank you. We will now deliberate on the appropriate discipline to be imposed.
Mr. President, I move to adopt the state's recommended discipline as set forth in the motions to deem and vacate the scheduled hearings.
I did not see any state's recommendations for discipline in their notices.
The motions to deem filed on behalf of the state by Mr. Hargraves and myself would request that the respondents be revoked.
Thank you. So I do have a motion on the table
I'll second.
and I have a second by Ms. Lehan. We'll do a roll call.
Mr. Solari,
Aye.
Mr. Dang,
Aye.
Mr. Minkus,
Aye.
Mr. Leba,
Aye.
Ms. Lehan,
Aye.
Ms. Walmsley,
Aye.
Mr. Tong,
Aye.
Mr. Goodman,
Aye.
Ms. Nair.
Aye.
Okay, thank you. And then I would defer to board staff and legal counsel on where we head next within tab 30.
Mr. President, if we can do 30D and 30I, and I believe we have a consent agreement issued and signed by those individuals. Am I correct, Mr. Hargraves?
Yes, in the case of Ms. Crosser, I believe she signed a consent for a voluntary surrender. In the case of Ms. McMeans, she signed a consent for a $250 civil penalty for failure to notify within 10 days. The state would ask that the board adopt the consent agreements in those cases.
Thank you. Board members, any discussion or questions for legal counsel?
Do we need to do them individually or can we do them together?
Mr.
You can,
President,
I'm sorry, go ahead, Mr. Harris.
Mr. President, members of the board, if you don't mind, if we could take those separately.
Okay, thank you. For Jamie Leanne Crosser.
I'll make a motion to adopt, to accept a consent agreement for voluntary surrender of the license.
Second.
Thank you. I have a motion by Mr. Solari and a second by Mr. Minkus. Do a roll call.
Mr. Solari,
Aye.
Mr. Dang,
Aye.
Mr. Minkus,
Aye.
Mr. Leba,
Aye.
Ms. Lehan,
Aye.
Ms. Walmsley,
Aye.
Mr. Tong,
Aye.
Mr. Goodman,
Aye.
Ms. Nair.
Aye.
Okay, thank you. And then the next one was 30I, Bailey Renee McMeans.
Mr. President, may I make a motion to accept the consent agreement for the $250 civil penalty?
Thank you, Mr. Solari. Have a motion.
Second.
Have a second by Mr. Minkus. A roll call, please.
Mr. Solari,
Aye.
Mr. Dang,
Aye.
Mr. Minkus,
Aye.
Mr. Leba,
Aye.
Ms. Lehan,
Aye.
Ms. Walmsley,
Aye.
Mr. Tong,
Aye.
Mr. Goodman,
Yes.
and Ms. Nair.
Aye.
Okay, thank you. Council, would you like to move to 30B?
Yes, thank you. Members of the board, Jean Galvin on behalf of the state. Ms. Fatima Sadeh is online. A complaint and notice of hearing was issued in this matter against Ms. Sadeh. She is a pharmacy technician trainee. her license is currently set to expire on September 30th of this year. In December of 2019, the Department of Public Safety notified us that she had been arrested for 2 counts of felony aggravated DUI on December 16th, 2019. And the date of the offense was September 8th of 2018. She was a licensed healthcare professional at that time, so she therefore had an obligation to notify the board of those criminal charges, and she did not. The board opened a complaint and issued a subpoena to Ms. Sadeha, and she did not respond. And that was in January of 2020. She had to complete a narrative, a written narrative of the events that led to her arrest and produce court records and police records, and she did not respond. The board followed up with another email to respondent asking her to comply with the subpoena and submit a written narrative. She did not respond. The documents that were obtained by the board indicate that the charges are still pending in Maricopa County Superior Court. After the complaint notice of hearing was sent to her, she failed to respond to that complaint and notice of hearing. So we filed a motion to vacate the hearing that was set this morning, and we did not hear from Ms. Sadeh at that time. She literally called my phone at 8:28 this morning. Her appearance and her response is untimely. I would ask on behalf of the state that the board grant our motion to vacate the hearing and deem the allegations in the complaint as true and correct and revoke the certification of Ms. Sadeha. She has demonstrated her inability to be regulated. Thank you.
Thank you. Board members, questions? And I do have, Mr. Harris, I do have the respondent present. Would it be appropriate to allow her to make a statement, or what do you recommend in this situation?
Mr. President, members of the board, I would give her an opportunity to address you.
Okay, thank you. Good morning, Fatima. I hope I'm saying your name right. If I'm not, please forgive me. But I want to welcome you to the meeting and give you a chance to respond to what you've heard so far.
Hi. Yeah, thank you. Actually, I just want to say, like, I just received a call last year. I believe it was in July or August, but I was moving my house, and I didn't have a like exact address to give them, and I just told them, please contact me with the phone, with the email or anything. But I didn't receive anything. I didn't receive any letters. I didn't receive anything. But at the time when I was working with my license, I haven't charged with the DUI. I just pulled over. My case just started last year in December, you know. I wasn't working like still I haven't charged with the DUI either. I'm just, my case is still pending, and my attorney didn't tell me anything to just, you know, do anything, because I'm new in the country. I don't know really anything about the laws, and you know, I really don't know. But I have a attorney, and my attorney didn't tell me anything to do. But like but still my case is still in process, you know. And my my license expired last year, and I quit like last year too. I believe it was October 2019, and I didn't want to work for the pharmacy anymore, and I didn't know it's going to be a problem.
Okay, thank you. Question for you. Are you currently working in pharmacy, and did you say that you no longer want to work in pharmacy? I just want to.
No, I quit last year, 2019, October 2019.
And you no longer
This is Goodman. Do you mean you don't want to work at that pharmacy or in the
No,
industry?
I don't want to work at a pharmacy anymore. Like
that particular one.
No, like for the pharmacy technician, as a technician anymore.
Okay.
Like I just quit because I'm studying, and like my major is not pharmacy, and I prefer to study and work for my major, you know.
Thank you for your statement. Board members, do you have any questions?
Mr. Dahey, what did you say your major is? You said it's pharmacy?
No, my major is not pharmacy, but I'm taking a pre-med things right now. I'm still in college. I'm taking just like pre-med classes to just get my license, like get my bachelor and go to the med school if I can.
Mr. President, may I?
Yes.
Ms. Sadeghi, when you got your license, did you understand that if you are charged, not convicted, but charged with an offense, you need to notify the board within 10 days? Do you know
I
that as
didn't
a
know
condition of
anything about
licensure?
that.
Okay.
I didn't know anything about that.
So, and then when you moved regularly, what did your email address change?
My email address didn't change, but my address, my home address did change. And honestly, this letter I have right now, my aunt just gave it to me yesterday. And it was,
Did you not receive any email correspondence from the board staff?
no,
At all, ever?
honestly, no.
Do
If
you
I,
have your
if
data
I
updated
did,
in
I
the
didn't
board's?
see it too.
Do you have your email updated correctly in the with the board?
Yes.
And you
I think
understand that is
because,
your responsibility?
yeah, because I just called and the attorney assistant just gave me the link by the email. But in the letter it says we send you an email, but honestly I didn't see any email.
And Mr. President, members of the board, I just like to remind the board that what's before you is the state's motion to vacate the hearing and deem the allegations of the complaint admitted. This is, the certificate holder is not under oath at this point. And, to the extent that you have asked the questions necessary for you to determine whether or not to grant the state's motion, I would ask that you limit the questions for that purpose. And one option, of course, is always to schedule this for a formal hearing if you feel like the case and these facts need to be developed further.
Thank you, Mr. Harris.
This is Jean Galvin. The state would oppose continuing this matter and setting it for formal hearing. The respondent has clearly demonstrated her unwillingness to communicate with this board. To my knowledge, there was no evidence in the file that any emails were bounced back or that any hard copy mail was returned. She's provided no compelling evidence for any reason to continue this matter, and therefore I would re-urge the motion.
Thank you, board members. Any questions or discussion?
I'm willing to make a motion.
Thank you, Ms. Nair.
I moved the board grant the state's motion to deem and vacate the hearing.
Second.
I have a motion by Ms. Nair and a second by Mr. Minkus. All those in favor?
Aye.
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 Any opposed? Okay, thank you, Ms. Nair.
I move to adopt the state's recommended discipline as set forth in its motion to deem and vacate the scheduled hearing.
And the discipline sought by the state is revocation of the license.
Second, Kevin.
Thank you. I have a motion by Ms. Nair and a second by Mr. Dang. We'll do a roll call, please.
Mr. Solari,
Aye.
Mr. Dang,
Aye.
Mr. Minkus,
Aye.
Mr. Leba,
Aye.
Ms. Lahan,
Aye.
Ms. Walmsley,
Aye.
Mr. Tong,
Aye.
Mr. Goodman,
Yes.
Ms. Nair.
Aye.
Motion carries, Mr. President.
Thank you.
Okay, thank you for your time today. What case is next on here? Help me out.
Mr. President, we're moving to agenda item number 31.
Agenda item 31A. This is Roderick A. Miller, board case number 19-0051. This is the date, the time, and the place where the matter involving Roderick A. Miller, case number 19-0051-PHR, is scheduled to be heard by the Arizona State Board of Pharmacy. This is a formal administrative hearing to determine if there have been violations of the board's statutes, rules, and whether disciplinary action is warranted. Board members present today include myself, Joe Leba, Lori Walmsley, Kristen Snare, Kevin Dang, Ruben Minkus, Mohammed Salari, Theodore Tong, Cedar Lahan, and Nick Goodman. Let the record reflect that the board members have been furnished copies of the complaint, notice of hearings, and all the pleadings of record. Will the parties please introduce themselves, starting with the state?
Seth Hargraves, Assistant Attorney General on behalf of the state. I do not believe Mr. Milner is present. The state has provided to the board in its packet a proposed consent agreement. This matter initially was set for hearing. The board had voted to offer Mr. Milner a consent agreement for a civil penalty for failure to timely disclose criminal charges. He did not accept, or there was no response at that time. The matter was set for hearing. After receiving the notice of hearing, Mr. Milner signed the consent agreement, sent it back. My understanding is he has also paid that civil penalty, verify with staff. But either way, the state would ask that the board adopt and accept the signed consent agreement to resolve this matter.
Thank you, Mr. Hargraves. Board members?
Mr. President, I'll make a motion to accept the consent agreement.
Second.
Thank you. Have a motion by Mr. Solari and a second by Mr. Minkus. All those in favor?
So roll call.
Roll call. Okay.
Mr. Solari,
Aye.
Mr. Dang,
Aye.
Mr. Minkus,
Aye.
Mr. Leba,
Aye.
Ms. Lahan,
Aye.
Ms. Walmsley,
Aye.
Mr. Tong,
Aye.
Mr. Goodman,
Aye.
Ms. Snare.
Aye.
Okay, thank you.
I have a question.
Yes.
I'm Ryan Miller, so I don't know if you guys were talking about me or not, but you guys butchered my name if you were.
Mr. Miller, good morning. And no, we were not talking about you. If you sit tight, I'll alert you when it is your turn in the agenda.
Okay, thank you.
Thank you. Okay, board staff and board members, moving on to 31B. Kelly Marie Davis, board case number 20-0422.
Mr. Leba, would you want to proceed with C, D, and E? I believe that those also involve consent agreements, whereas Kelly Marie Davis will be actually.
Okay, board members, I'm not sure if you picked that up. The recommendation was if we wanted to proceed with C, D, and E as they were consent agreements. Is that right, Ms. Galvin? Okay. And I do recommend that we do that. Mr. Harris, should we accept each one individually, or can we accept the consent agreements for 31C, D, and E at one?
Mr. President, members of the board, I would ask that you accept them or consider them individually.
Okay, thank you. 31C, Joshua Michael Winteran, case number 20-0248.
Yes, Seth Hargraves. This was a matter that the board had voted to hearing. Mr. Winterton has since signed a consent agreement agreeing to voluntarily surrender his license in lieu of proceeding forward. The state would ask that the board accept that consent agreement to resolve this matter.
Thank you, Mr. Hargraves. Board members?
Mr.
I'll make the
President,
motion. Sorry. Go ahead, Mr. Slide.
I'll make the motion to accept the consent agreement to voluntarily surrender the license.
Second.
I have a motion by Mr. Solari, a second by Ms. Snare. A roll call.
Mr. Solari,
Aye.
Mr. Dang,
Aye.
Mr. Minkus,
Aye.
Mr. Leba,
Aye.
Ms. Lehan,
Aye.
Ms. Walmsley,
Aye.
Mr. Tong,
Aye.
Mr. Goodman,
Yes.
and Ms. Nair.
Aye.
I'm sorry. Can I ask a question? Hello?
Joe,
Yes, you
you're on
can.
mute.
Go ahead.
I just have a question. Like, what should I do right now? Do I have to stay or do I have to go?
No, we thank you for your time today, and you are dismissed. We've heard your case, and again, thank you for your time.
Thank you very much, Your Honor.
Thank you.
Have a wonderful day.
You too. Okay, 31D, Shaquille Robinson, board case number 20-0403.
Yes, Seth Hargreaves, Assistant Attorney General. This is a case, Ms. Robinson had previously entered into a consent agreement with the board for the payment of a $250 civil penalty for failure to timely notify the board of charges. She failed to pay the civil penalty within the time set forth in the consent agreement. The matter was set for hearing. After receiving the notice of hearing, Ms. Robinson submitted payment for the previous consent agreement. The state would ask that the board accept that late payment and vacate further proceedings.
Thank you, Mr. Hartgraves. Board members, questions?
Mr. President, I'll make a motion to accept the late payment and vacate the hearing.
Second.
I have a motion by Mr. Solari and a second by Mr. Minkus. All those in favor? Roll call. Okay.
Aye.
Tried to get away with the team, but we do the roll call.
Mr. Solari,
Aye.
Mr. Dang,
Aye.
Mr. Minkus,
Aye.
Mr. Leyva,
Aye.
Mrs. Lehan,
Aye.
Ms. Walmsley,
Aye.
Mr. Tong,
Aye.
Mr. Goodman,
Aye.
and Ms. Nair.
Aye.
Thirty-one E, Ryan Allen Manley, board case number 20-0307.
This is a case, again, Seth Hargreaves, Assistant Attorney General, case of an individual who failed to timely notify the board of pending criminal charges. The matter was set for hearing. After he did not respond to the notice of hearing, after receiving the motion to deem, he signed the consent agreement, sent it in. The state would ask that the board accept the consent agreement to resolve this matter and vacate the hearing.
Thank you, Mr. Hargreaves. Board members?
I'll make the motion to accept the consent agreement for the $250 civil penalty.
Second, Kevin.
Thank you. Have a motion by Mr. Solari and a second by Mr. Dang.
Solari,
Aye.
Mr. Dang, Mr. Dang,
Aye.
Mr. Minkus,
Aye.
Mr. Leyva,
Aye.
Ms. Lehan,
Aye.
Ms. Walmsley,
Aye.
Mr. Tong,
Aye.
Mr. Goodman,
Aye.
and Ms. Nair.
Aye.
Okay, thank you.
Mr. President, I believe that, well, Mr. Miller, Ryan Miller is here, and item 32A, the motion for rehearing. We still have to do the administrative hearing for Kelly Davis, but I don't believe she isn't present. If you want to take 32A, because Mr. Miller is here, I would not object.
Okay, thank you for that. Agenda item 32, motions for rehearing review. This is 32A, Ryan Anthony Miller, board case number 20-0267. This is the date, the time, and the place where Ryan Anthony Miller's motion for rehearing is scheduled to be heard by the Arizona State Board of Pharmacy, case number 20-0267-PHR. Will the parties please identify themselves for the record, starting with the counsel for the state?
Seth Hargraves, Assistant Attorney General on behalf of the state.
Mr. Miller, it's your turn to state your name for the record.
Ryan Miller.
Thank you. Pursuant to AAC R423-128D, the board may grant a rehearing of the case of Mr. Miller if Mr. Miller establishes that one or more of the 8 grounds listed in the rule materially affected his rights during the administrative proceedings. The board has reviewed Mr. Miller's motion for reviewing and the response to the motion filed by the state. Each party will have 5 minutes to address the board on this matter. This is the time for legal argument related to the grounds of rehearing, and the parties should not use this time to present new evidence or testimony to the board regarding the merits of this case. Mr. Milner, in your arguments to the board, please clearly identify and explain the grounds that support your motions for rehearing. Mr. Hargraves, in your arguments to the board, please clearly identify and explain why the state does not believe that Mr. Miller is entitled to a rehearing. We will now proceed to oral argument. Mr. Miller will present first, followed by Mr. Hargraves on behalf of the state. Mr. Miller, if you would like to present.
First of all, I have never had a record of a physical assault charged in my employment history or my personal life or nothing. So I need you guys to prove that I have such an act. And also, during my employment with Community Compounding Pharmacy in Lake Oswego, Oregon, that employer had numerous false accusations against me. And when they complained about me to the Oregon Board of Pharmacy, I attempted to get information from them regarding these false accusations, and they would not give them to me. I just feel like I've been discriminated against because the Oregon Board has not given me the material that I requested, and that I've been truthful through this whole process, despite what you guys say my late response was to all these different notifications you guys sent me, because I was out of town and couldn't get my mail. So besides lying in my initial correspondence with you, I am a very truthful person and don't lie about anything, and thus I'm 100% innocent, whether you guys prove it or not.
Okay, thank you, Mr. Miller. Mr. Hargraves?
Yes, thank you. The board's rules set forth the grounds for which the board may grant a rehearing or review. It was up to Mr. Miller to set forth those grounds in his request to you. Nowhere in his request did he cite to any specific provision to justify granting a rehearing or review. If you look at the board's rules, R4-23-128D, it sets forth 8 grounds. Although Mr. Miller did not specifically cite any of them, it could be viewed that his request was under D4, newly discovered material evidence that could not with reasonable diligence have been discovered and produced at the hearing, or 8, that the findings of fact decisions are not justified by the evidence contrary to law. Now, Mr. Miller states that there's never been any charges against him for violence or assault. That is simply not true. The evidence that was presented in this matter at the hearing was that the allegations were that he had been disciplined in another state. He failed to comply with a board subpoena. the evidence that was presented showed that Mr. Miller voluntarily entered into a consent agreement with the Board of Pharmacy in Oregon. In that consent agreement, he admitted to the allegations that he had physically assaulted another employee while working as a pharmacy tech at Community Compounding Pharmacy in Lake Oswego on October 18th, 2018. His admission in that document to having assaulted a coworker is evidence of the violation set forth in the notice of hearing, that he committed an offense in another jurisdiction that if committed in this state would be grounds for discipline. Additionally, the evidence showed that he did not respond to the subpoena timely and provide the board the information that had been requested. When initially reached out to him after he had failed to comply with the subpoena, his responses, as he admitted today, he lied to the board. First, he said, well, you've got the wrong person. I don't have a license here. Leave me alone or I will sue you. Mr. Miller has failed to provide this board with any new evidence. All he is doing is rehashing the same stale arguments, unsupported arguments that he raised at the hearing. The evidence and testimony supported the violations alleged and support the board's decision to revoke the license, which the board did. He has failed to meet his burden to establish that there's any grounds for this board to grant him a rehearing or review, and thus the state would ask that his request be denied. Thank you.
Thank you, Mr. Hartgraves. Okay, does any board member have questions for the parties? Okay, the board has heard the arguments of the parties and reviewed the pleadings filed in this matter. The board may grant a rehearing. The board may also deny the motion and affirm the prior decision. If the motion is to grant a rehearing, the matter of the motion must specify the grounds on which the rehearing is based. Rehearing would then be limited only to specified grounds. Board members, do I have a motion?
Mr. President, you want me to do it? I'll make the motion that we deny the request for a rehearing.
Thank you, Mr. Minkus.
Goodman second.
And I have a second by Mr. Goodman. And we will do a roll call. No, all those in favor?
Aye.
Aye.
Any opposed? Okay, thank you. This
I
concludes
think
the
you guys
matter.
are making a mistake. You should read the testimony I sent
Hang
to
on one
Pam
second,
Gandhi.
please. The board's decision will be reduced to written order and served on the parties. The parties will have further appeal rights with the explained in the board's order. Thank you all for attending today. Mr. Miller, thank you for your time today.
I think you need to read the testimony.
Okay, moving on to, do we
Read the
need
testimony
to
of
take
Pam Gandhi.
a break, Ms. Galvin? And
Read the testimony.
Anytime, if you want to proceed, if the board members need a break, that's fine.
okay, board members, let's do a 10-minute break and then we will reconvene and pick up on the hearing. Thank you. Okay, welcome back, everyone. Before we get going, I will have Dr. Gandhi do a roll call, please.
Okay, Mr. Solari,
At your service.
Mr. Dang,
Present.
Mr. Minkus,
Here.
Mr. Leba,
Present.
Ms. Lehan,
Present.
Ms. Walmsley. Ms. Walmsley, you're muted. Ms. Walmsley. We'll get back to Ms. Walmsley. Mr. Tong.
Present.
Mr. Goodman.
Here.
And Ms. Snare.
Here.
Okay, let's go back to Ms. Walmsley. I'll request unmute. Still can't hear you, but I do see you, so I'll mark you as present.
Okay, 31B, Kelly Marie Davis, board case number 20-0422. This is the date, the time, and the place for the matter dealing with Kelly Marie Davis, board case number 20-0422 is scheduled to be heard by the Arizona State Board of Pharmacy. This is a formal administrative hearing to determine if there have been violations of the board statutes and rules and whether disciplinary action is warranted. Board members present today include Joe Leba, Lori Walmsley, Kristen Snare, Kevin Dang, Ruben Minkus, Mohammed Salari, Theodore Tong, Cedar Lehan, and Nick Goodman. Let the record reflect the board members have been furnished copies of the complaint, notice of the hearings, and all pleadings of the record. Will the parties please introduce yourselves?
Jean Dalton, Assistant Attorney General on behalf of the state.
I'm not sure they picked you up, Jean.
I could hear her.
Dalton, Assistant Attorney General on behalf of the state.
Just to check your board members. Could you hear Ms. Galvin?
I could. She's quiet, but I could hear her.
A little, yeah.
Okay, let me know if you cannot hear. And then is Marie Davis, Kelly Marie Davis present?
President, I do not see her in our meeting.
Okay. A hearing of this nature differs from court proceedings. The technical rules of evidence do not apply. Reliable hearsay evidence is admissible. The board will entertain objections concerning irrelevant, repetitious, and otherwise inadmissible evidence. Each party will be allowed to present evidence, cross-examine opposing witnesses, and make a closing argument. In a disciplinary proceeding, the state bears the burden of proof and shall present its case first.
I'm ready to proceed to, Mr. President, with a brief opening statement.
The mission of the Arizona Board of Pharmacy is to protect the health, safety, and welfare of the citizens of Arizona by regulating the practice of pharmacy. It accomplishes this mission in part by issuing licenses to
Mr. President, I am having difficulty with Ms. Galvin.
So am I.
Same.
Okay, how about this?
Yes.
Better.
Better.
All right, the case before. Okay, that's fine. The case before you today involves Ms. Kelly Marie Davis, who is a licensed pharmacy technician. You will hear today from Ms. Jennifer Galvanon, the board's deputy director, who will testify that we are here for essentially two reasons. First, Ms. Davis failed to disclose to the board that she was arrested and charged with one misdemeanor count of disorderly conduct and one misdemeanor count of failure to comply with a court order, both involving domestic violence. The conduct occurred in September of 2020 in Lake Havasu City, Arizona. Pursuant to 32-3208, Ms. Davis was required to report the charges to the board within 10 days, and she failed to do that. We believe that Ms. Davis pleaded guilty to the offenses and is currently participating in a diversion program. Secondly, as that case was waiting to be heard by the board at the December 2020 meeting, the pharmacy manager at Havasu Regional Medical Center, where Ms. Davis was employed, notified the board that Ms. Davis had been terminated by the hospital for violating its drug-free workplace policy. After testing positive for a substance that was banned by the hospital, Ms. Davis was terminated from her position. As required, the hospital notified the board, and the board's executive director issued an interim order for a substance use evaluation. Ms. Davis had 30 days to complete the evaluation. She has yet to comply with the order. Given the allegations against Ms. Davis, the board summarily suspended her on January 9th, 2021. At the conclusion of the proceeding, the state requests that you find Ms. Davis' conduct in violation of ARS 32-3208A, which is failing to notify the board of pending criminal charges, and 32-1901.0116, which is violating a board order. At the conclusion of the hearing, the state requests that you revoke the certification. The state would like to call its first witness, Ms. Jennifer Galvanon.
Yeah. Dr. Gotti, would you like to swear her in?
Please raise your right hand. You swear that the testimony you're about to provide will be truthful and complete?
Could you please state your name for the record and tell us for whom you work?
My name is Jennifer Galnavon. I work for the Arizona State Board of Pharmacy.
And what position do you hold with the board?
As Deputy Director?
You are a licensed pharmacist, is that correct?
Yes.
And what are your responsibilities as Deputy Director?
I assist the Executive Director in the administrative functions of the agency, including matters related to licensing, complaints, and regulatory compliance.
Through your employment with the board, are you familiar with Ms. Davis?
Yes.
And can you explain to us briefly what are the nature of the proceedings against Ms. Davis?
Ms. Davis Ms. Davis has failed to disclose criminal charges to the board, and she has failed to comply with a board order.
And she is a licensed pharmacy technician, is that correct?
That's correct.
Let's first talk about the criminal matter that you referenced. How is it that this issue first came to the attention of the board?
The board was notified by DPS on September 25th, 2020, that Ms. Davis was arrested for misdemeanor disorderly conduct and misdemeanor failure to comply with a court order, both involving domestic violence, on or about September 25th in Lake Havasu City, Arizona.
Please refer to what has been marked for identification as State's Exhibit Number 1. Is that the letter that you just referenced?
Yes.
Was she a licensed pharmacy technician at the time of her arrest?
Yes.
Is she required to maintain a valid fingerprint clearance card?
Yes.
So the board receives this notification. What are the next steps that are taken?
The board opened a complaint against Ms. Davis's license after receiving notification from DS.
Does the board notify Ms. Davis of that complaint?
Yes, they notified her of the complaint. We notified her of the complaint on October 14th, 2020.
Would you please refer to what has been marked for identification as State's Exhibit Number 2? And is that the notification that you provided to her?
Yes.
What follows from that notification is a subpoena. Was that also issued to Ms. Davis?
Yes, it was.
And the notice of complaint and the subpoena requires what of Ms. Davis?
The subpoena required Ms. Davis to provide a detailed description of the events that led to her criminal charges, the status of her charges, and any remedial corrective actions she had taken, a response to the allegations of failing to report the charges filed against her within 10 working days, copies of the report from the arresting agency and records from the adjudicating court, and those copies had to be legible, and then to provide a current place of employment. By October 28th, 2020 at 5 p.m.
And did she comply with the subpoena?
Not within that time frame.
Does the board staff notify her of her duty to comply with the subpoena and that she is untimely?
Yes.
Please refer to what has been marked for identification of State's Exhibit Number 3. Is that notification?
Yes.
And it is sent on October 29th, which was the day after her documentation was due. Is that correct?
That's correct.
Do you provide Ms. Davis with additional time within which to comply with that subpoena?
Yes.
And what is that new date?
November 5th, 2020.
Does she respond to this email?
Yes.
Please refer to what has been marked for identification of State's Exhibit Number 4 and identify that document for us.
This is a written statement from Ms. Davis.
And does it provide basically a narrative of what occurred that led to the criminal charges?
Yes.
And she also provides court documentation, does she not?
That's correct.
So she responded to the subpoena, but it was late.
Correct.
Can you tell me the statute? Is it Arizona 323208 that required her to report the charges within 10 days?
That's correct.
And she provided an required in 3208?
No, she did not.
I would move exhibit 1, 2, 3, and 4 into evidence, please.
Mr. President, may I make a motion to accept exhibits 1 through 4 as evidence?
Have a motion?
Second.
Second by Ms. Snare. All those in favor?
Aye.
Aye.
Any
Aye.
opposed? Thank you.
So the staff is investigating her failure to notify the board of her criminal charges. The matter is set for board consideration at December hearing, a meeting. What happened in the interim?
On November 10th, the board is notified by Renee Frick, pharmacy director at Havasu Regional Medical Center. The board is notified that Ms. Davis has been terminated for violation of the hospital's drug and alcohol policy.
Please refer to what has been marked for identification as State's Exhibit number 5. Is this that email that you just referred to about the notification?
Yes.
And Ms. Frick refers to the event that led to Ms. Davis' termination, is that correct?
Correct.
And could you just briefly explain to us what that event was?
Yes. So Ms. Frick states that on October 24th, 2020, an anonymous source contacted Lake Havasu City Police Department and stated that Ms. Davis may be intoxicated at work. The police came to the hospital pharmacy and met with the house supervisor, who contacted Ms. Frick and the house supervisor, and the hospital's drug and alcohol-free workplace protocol was initiated.
And so did they make her or require her to undergo a drug screen?
Yes.
Please refer to what has been marked for identification as State's Exhibit number 6 and members of the board. This isn't a separate packet, it's a confidential document, and it's been marked as State's Exhibit number 6. Could you please tell us what this document is and what does it show us?
This document is a report summary of a drug screen urinalysis for Ms. Davis.
And does she test positive for prohibited alcohol according to the hospital policy?
Yes.
I would move exhibit 5 and 6 into evidence, please.
Mr. President, I'll make a motion to accept exhibits 5 and 6 into evidence.
Thank you.
Second.
Have a second. All those in favor?
Aye.
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 Any opposed? Thank you.
So now we have this positive drug screen result. She's been terminated from her position. What happens next as far as the process in the board office?
On the 23rd of November, 2020, the board issued Ms. Davis an interim order for substance use and abuse evaluation.
Please refer to what has been marked for identification of State's Exhibit number 7. Is that the interim order that you just referenced that was issued in November of 2020?
That's correct.
Okay. How was the order sent to respondent?
This order was sent to Ms. Davis by email, certified mail, and regular mail.
Were the hard copies of this document returned to the board?
No.
Did the email bounce back?
No.
Pursuant to the order, respondent is to notify the executive director of the date of evaluation, the name of the provider within 10 days. Is that correct?
That's correct.
Is it correct that she had 30 days to complete the evaluation?
Yes.
Does she complete the evaluation in a timely manner?
No.
Does she complete the evaluation at all?
No.
When Ms. Davis fails to comply with this order, what step does the board take?
The board notified Ms. Davis that the Board of Pharmacy would consider her complaint filed against her license at a special meeting.
Please refer to what has been marked for identification of State's Exhibit Number 8. Is that the notice letter that you provided to her?
Yes.
And it went to her last address or record, is that correct?
Correct.
Was it returned to the board?
No.
Then the notice letter states that the meeting of the board is going to be held on the 9th, on January 7th, I'm sorry, is that correct?
That's correct.
And did the board hold that meeting?
Yes.
And what occurred at that meeting?
Was summarily suspended.
Could you please refer to the identification of State's Exhibit Number 9 and tell us what that document is?
Could you repeat your question, please?
Could you please refer to what has been marked for identification of State's Exhibit Number 9 and identify that from the document for us?
Yes, that is the interim findings of fact, conclusions of law, and order for summary suspension of license.
Did Ms. Davis appear at the hearing, or did an attorney appear on her behalf?
No.
What is the factual basis upon which the board relied in making its determination that her license should be summarily suspended? If you refer to Exhibit 9, the interim findings of fact refer to the termination at the Havasu Regional Medical Center, is that correct?
Yes. So the basis was based on her termination from Havasu Regional Medical Center as a result of her positive test for substance, failure to comply with a board order, and failure to disclose her charges as required by ARS 323208.
And this interim order and summary suspension was also sent to Ms. Davis via certified mail, electronic mail, and regular mail, is that correct? I'm sorry, according to the certificate of mailing, it was certified mail, is that correct?
That's correct.
Okay. Was that mail returned to the board?
No.
After the board summarily suspends her license, the board set this hearing for today, is that correct?
Correct.
And please refer to what has been marked for identification of State's Exhibit Number 10. Is that the complaint and notice of hearing that was issued to Ms. Davis?
Yes.
And this was also sent to her record, or her address of record, is that correct?
Correct.
And it's the complaint notice of hearing states the factual allegations and the alleged violations of law, is that correct?
That's correct.
Does Ms. Davis eventually file some kind of communication with the board about these allegations?
Yes.
Ms. Galvin, sorry to interrupt, but it's very difficult to hear you and it's getting worse.
Okay.
I think Jennifer, if you mute while she's talking, and you'll just have to continually do it, it'll get better.
We are almost done. I'm asking the board to refer to State's Exhibit Number 11. And could you please identify this record and just very briefly summarize the contents?
Yes, this is a statement provided by Ms. Davis on January 17th, 2021. It describes altercations between herself and the father, discusses the loss of a family member, and it states that she is not a normal user of alcohol or marijuana.
Does she explain why she did not comply with the interim order and get the evaluation?
No, it does not.
I would move exhibits 7, 8, 9, 10, and 11 into evidence, please.
Mr. President, may I make the motion to accept exhibits 7, 8, 9, 10, and 11 as evidence, please?
Thank you, Mr. Solari. I will second. All those in favor?
Aye.
Aye. Any opposed?
Could you please explain for the board what discipline that the board is seeking to impose today against Ms. Davis and why that discipline is being recommended?
So the board is seeking revocation of Ms. Davis's license as she has demonstrated that she is not capable of being regulated.
Mr. President, the board has nothing further to offer at this time. Ms. Davis has not appeared. Would you like me to proceed with the closing argument unless there are questions by board members?
Yes, I would. I'll pause real quick to see if board members do have any questions, and then if they don't, you can proceed. Okay, thank you.
Okay. Mr. President, members of the board, the ability to practice one's chosen profession is a privilege. It is not a right. A licensee is subject to disciplinary action by this board if that person has committed unprofessional conduct. The uncontroverted evidence presented today establishes by a preponderance of the evidence that Ms. Davis, a certified pharmacy technician, has committed unprofessional conduct and is therefore subject to disciplinary action. The facts presented demonstrate that she was arrested and charged with 2 criminal offenses involving domestic violence and that she failed to inform the board of the pending charges pursuant to ARS 32-3208A. Upon information and belief, she has pleaded guilty to at least one of those charges and is in a diversion program. In addition, upon her termination from Havasu Regional Medical Center, she was ordered to undergo a substance use evaluation within 30 days of the order. Again, Ms. Davis violated state statute when she failed to complete the evaluation. This is unprofessional conduct pursuant to ARS 32-1901.01C16. The state respectfully requests that you revoke Ms. Davis's certification. Thank you.
Thank you. This concludes the evidentiary portion of the hearing. The board will now go into discussion, and I will hand it over to board members. In the general discussion, board members, we can begin to have a discussion and entertain motions on findings of fact, conclusions of law, and the final order.
I'll make a motion.
Thank you.
I move that the board grant the state's motion and deem the allegations in the complaint and notice of hearing as admitted.
Mr. President, members of the board, Ms. Sneer, perhaps what I could ask you to do is consider modifying that motion. And if the board members could take a look at State's Exhibit 10, and if you agree, perhaps you could first entertain a motion to consider adopting the factual allegations as your findings of fact in this matter.
Okay, I move to accept the factual allegations and findings of facts and conclusions of law in this matter.
If we could just perhaps take it one motion at a time. So my understanding, Ms. Sneer, is that your motion is to adopt the factual allegations set forth in the complaint and notice of hearing as your findings of fact in this matter.
Correct.
Thank you.
Do I have a motion?
I will second.
I have a second by Ms. Walmsley. All those in favor?
Aye.
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 Any opposed? Thank you. Ms. Snare?
Mr. Harris, do you have any other guidance? Is it
Sure.
okay for me to go back to where I was at, to deem the allegations of the complaint and notice of hearing as admitted?
I think if we could take the alleged violations of law as your conclusions of law as the next motion, if you and the rest of the board are in agreement.
Yeah, I take the alleged violations of law and factual allegations as admitted.
Almost, if you wouldn't mind, I could, the motion I think could be to adopt the alleged violations of law set forth in the complaint notice of hearing as your conclusions of law in this matter.
Thank you. I will, yes, I make that my motion.
And I will second. All those in favor?
Aye.
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 And
Any
then,
opposed?
oh,
Any
I'm sorry.
opposed?
And then, Mr. President, members of the board, Ms. Snare, now would be the time to consider what final action you'd like to take. Again, as a reminder, the state is recommending revocation.
Make a motion to accept the state's recommendation of revocation.
Thank you.
Second is Kevin.
Thank you. I have a motion by Ms. Snare and a second by Mr. Dang. We'll do a roll call.
Mr. Solari,
Aye.
Mr. Dang,
Aye.
Mr. Minkus,
Aye.
Mr. Leba,
Aye.
Ms. Lehan,
Aye.
Ms. Walmsley,
Aye.
Mr. Tong,
Aye.
Mr. Goodman,
Aye.
Ms. Nair.
Aye.
Thank you. Mr. Harris, before I move to conclusion, is there any loose ends that you need us to clean up?
Not that I'm aware of. Thank you for asking.
Okay, thank you. This concludes the proceeding. The board's decision will be reduced to a written order, and thank you for your attendance today.
Thank you, board members.
Thank you.
Thank you, Mr. Harris.
Okay, board members, with scheduling and appointments at hand, we are going to take a break until 10 o'clock. It is 9:48, and then we'll reconvene. Thank you. Okay, welcome back, everyone. Before we get going, I'll have Dr. Gandhi do a roll call.
All right, Mr. Solari,
Present.
Mr. Dang,
Here.
Mr. Minkus, Mr. Minkus. I see him. All right. Well,
Here.
there you go. Mr. Leba,
Here.
Ms. Lehan,
Present.
Ms. Walmsley,
Here.
Mr. Tong.
Here.
Mr. Goodman,
Here.
and Ms. Nair.
Here.
Okay, I will defer to Jennifer and Cam on where on the agenda we go next. I think we're going into the conferences.
Correct, Mr. President. We have two conferences remaining on the agenda, 29D and 29E. You're muted, Mr. President.
My apologies. 29D 20-0348, Optum Pharmacy 801, and PIC Chris Griffey.
Hello, Roger Morris, counsel for Optum.
Good morning.
And I'm Chris Griffey, pharmacist in charge of Optum Pharmacy 801.
Good morning. And then do I have Ms. Richardson available to give a brief opening, and then we'll defer to Mr. Morris and Mr. Griffey as well.
Yes, this is Sharon Richardson. We have a complaint that was filed by a patient stating that she received her injectable progesterone prescription from Optum Pharmacy in the mail without the syringes that were required to administer the medication. The patient was unable to contact the pharmacy in time to receive them before her dose was needed, so she was forced to obtain the syringes from a local animal supply store. I spoke to Mr. Griffey, pharmacist in charge, about the incident, and we determined that this prescription was a refill of an original prescription order that had originally been filled on July 8th of 2020. That original prescription was written to include syringes for administration and was correctly filled at that time. The prescription was then requested to be refilled on August 5th, 2020 by the patient. The refill request was received by and submitted by what is called a patient care coordinator working out of the Tucson facility through a shared services agreement. That patient care coordinator only entered the refill for the progesterone and not a refill for the syringes. This particular patient care coordinator does not hold a license as a technician, a trainee, a pharmacist, or an intern in the state of Arizona. In talking with Mr. Griffey, I did inform him that as an unlicensed individual, he would not be permitted to process or enter refills into the system. Mr. Griffey at that time was unaware of this. I did obtain a copy of the job description of a patient care coordinator, and that is included in your packet for your review. The job description includes various items, including consulting with patients and providers on treatment plans. I've listed a few things there for you that you can review. The requirements of the job function are a high school diploma or equivalent, and the job is being performed by non-licensed individuals. However, if you look at the job description, many of the functions listed are reserved for either technicians or pharmacists in the state of Arizona.
Okay, thank you, Ms. Richardson. Mr. Griffey, Mr. Morris, would you like to make a comment?
Sure. I thought I'd give you an overview, and then Mr. Griffey will give you some specifics about it. This matter breaks down into two distinct issues. One is the filling of the prescription and the failure to send the syringes. Before I get into that, I want to make sure each of the board members received the supplemental materials we sent to the board on February 1st. It contains 4 exhibits, and I want to make sure each of you have received those. The first exhibit, marked Exhibit A, is an actual transcript of the telephone call between the patient care coordinator and the patient. The second exhibit, Exhibit B, is the board's listing of what are permissible duties for pharmacy clerks pulled from the board's website. The third exhibit, Exhibit C, is the job profile for an associate pharmacy care coordinator. And Exhibit D is the pharmacy staff job responsibilities, because I think these will become very relevant as we walk through this. For the actual prescription that was filled, the pharmacy care coordinator talked to the patient, and if you read the transcript, and I did forward the audio itself to the board if the board wanted to actually hear the audio, but the transcript is word for word accurate with it. You'll see that he got her patient demographic information. He asked her what he wanted. He confirmed what it was to be there. And there was no mention of the syringes at all. This is a matter of simply some miscommunication, and there's been some retraining of the pharmacy staff for when there's a communication like that, to make sure that when someone is seeking an injectable like this, they discuss it, because not every time does someone need syringes. We don't want to be filling syringes if it's not necessary to be able to do it. The second, and I think more relevant issue for the board, is the job description and the listing of duties. And I'll let Mr. Griffey explain to you what happened, but what you have is a listing of a whole bunch of functions of a bunch of people combined there. What you ultimately hear from him is that the care coordinator in this case stayed within the bounds of what they're supposed to do. They accepted the request for a refill, and they passed it on to the pharmacy technician and then the pharmacist who actually filled it. And they've redone a number of job functions so that they can make sure it's clear. But at no time was the clerk able to do anything other than what a clerk was allowed to do. At no time are technicians allowed to do anything other than what technicians are allowed to do. And at no time is a pharmacist allowed to do it. Mr. Griffey unfortunately gave Ms. Richardson a document that was confusing and was the wrong document. So with that, I'll start with Mr. Griffey and have him explain what happened with the script and then the job description. Chris?
Thank you, Mr. Morris. Just real quick, Jennifer, could you confirm that the board members did receive the supplemental information that was sent to everybody? I have it.
It was sent to all of the board members on February 2nd.
Okay, thank you. Okay, Mr. Griffey.
Thank you. So as Roger said, there's two parts to this. For the prescription part of it, the initial complaint, the patient called in to order a refill. That would have been the first refill on that prescription on August 5th. Our agent took that refill request, scheduled the delivery, confirmed payment information, co-pays, and then passed that request on electronically to licensed staff who then filled and did a final verification of the order before it shipped. At no time in the call did the patient request syringes. The agent did not ask if she needed them either. It's not necessarily unusual for us to ship an injectable medication without supplies. We do our supplies in packs of 10, and if a patient receives supplies on a previous fill that was not for 10 injections, they very well may have extra at home. So it's not in our practice to automatically throw in needles and syringes with every single fill. It's usually on the first fill, and then we should be doing it by a per patient request going forward. In this case, the patient, as Ms. Richardson said, had to obtain supplies from a local source. And then we did still continue to refill for this patient with no other incident several times after this event. In response to this, we have provided retraining to all staff who take calls like this to make sure that they're asking patients if they need supplies on these refills. We are also streamlining it so that only agents on our fertility team who are a little more specialized in that area are handling these refill requests. So they would be a little more likely to ask, to recognize when those supplies may be needed. Moving on to the job description part of it, the document that I provided to Ms. Richardson at the time of her visit, that was my mistake. It was the wrong document. That was not actually a job description, so to speak, for what this agent was doing in their role. That document is more of a very general profile of a pharmacy job family, mainly intended for internal purposes. And it's meant to apply very broadly to all pharmacy staff in various different environments across Optum, which is a large national company. So that was not, I should not have provided that. That was a mistake on my part. In this case, this agent was a customer service representative. He's non-licensed pharmacy support staff, and his ability to perform tasks in our system would have been limited by his role in that system. In this case, he was registered as a non-licensed tech, and in our software, non-licensed techs are only able to do non-licensed roles based on state law. So, and that is all regulated by their biometric. Every time they complete a task, they have a little fingerprint scanner, and that is attached to their profile in the system. So he would not have been able to perform any technician or pharmacist tasks in the system at all, even if he tried. So going forward with this, we are currently going through discussions on how to recode in our system the customer service reps to a internal job code that more aligns with their responsibilities, a little more precisely, be a little more easier to understand than this kind of very broad document that I gave to Ms. Richardson. We've also created a new document which more accurately reflects allowable tasks for non-licensed staff, licensed techs, and pharmacists. That would apply mainly to pharmacies within our same field. And that document has been provided in the supplemental information that Roger provided. And that is all I have.
Okay, thank you.
I have a question.
Mhm.
I see the transcript that the clerk takes the information. What do they do after they gather this information?
They enter that into our system, into a notes field. We have a template that they fill out to make sure that our ship notes, we call them, are identical, are always contain the appropriate information. And then payment information, they kind of say in that template that the patient has approved payment on credit card on file, or or that there was zero copay, something like that. And then they just scan down with their finger on the biometric, and the task goes on to licensed staff to complete at that point.
Thank you.
Mr.
I
Griffey,
think you. Go ahead, Joe.
how do they get a price if they're not processing the script at that point?
They usually will go off of the previous fill. They'll say, it looks like there, when you got this last month, there was a $5 copay, for example. If that's the same, do you approve us to bill the card on file? If the price changed later in the process, we would call the patient back to let them know of a difference in price and get a new approval on that.
That's not what I saw in the transcript. They offered a price, then they corrected the price and got permission to bill the patient on their credit card. Is that not correct?
Yeah.
I can't say for sure. He may have been looking at the previous month's dispense, saying it looks like there was he could be saying I showed that there's a copay, meaning this is what the copay was on the previous fill. He shouldn't have been able to see what the price would be on this one, the final price on this, until it was completed, or at least.
I'm going to read from the transcript. Mr. Bannon says, I do show there's a copay of $7.95 on this. May I put this on your visa that ends in this number? Caller says, that'd be great, thank you. Mr. Bannon says, you're welcome. Mr. Bannon then says, it's actually $7.65. Caller, all right, laughter. Mr. Bannon, yeah, there's one of those Walmart kind of sales on this today.
Mo, you're muted.
I'm sorry.
You're still muted.
Okay, there we go. Sorry. So I'm reading the transcript, Mr. Griffey, and it doesn't really confirm what you said.
To that point, Miss Richardson, do we have in the investigative file? I didn't see it as a part of the documents here. The transaction history for this actual fill of the prescription. What I'm hearing from Mr. Griffey and Mr. Morris is that the original job description provided is not accurate. There is no way for this person to do the data entry for this prescription, which we were concerned is a duty reserved for a technician. And then we received an additional job description. Do we have any proof that the clerk did not?
What I observed, Ms. Walmsley, when I investigated, the way that I obtained Mr. Bannon's name was actually from the prescription processing system. They use a system that I'm fairly familiar with, and this particular processing system was not a notes system. It actually listed the order entry person as Mr. Bannon. And that's when I looked up that individual in our licensing system and found that he did not have a license. This particular system, in order to obtain a price, you would process the prescription. in order to, there was no way in this particular system to just send a note to somebody else. There was not another technician listed who actually ran the prescription refill. It was under Mr. Bannon's name and sent to fulfillment at that point to be physically filled.
To be very clear, we have a list. There were 5 people who were involved in this prescription. Mr. Bannon was on the phone. There was another technician who dealt with benefits, another technician who was the formal technician for the PV1 process, then the pharmacist involved, and then there was the actual fulfillment. All 5 of those people are listed. Mr. Bannon is the one who received the telephone call, put the information in there, and then passed it on. We're talking about an electronic pass on in this one in terms of processing. I mean, we can get into a debate about semantics, about what's the word process versus the word passes on. After Mr. Bannon finished his, it went to a technician who was the next person to do it, and then to a pharmacist. When we have the people working remotely in the different computer systems, there are different systems that are used in modifications to be made in this electronic world. But Mr. Bannon took the information as allowed by a clerk and then passed it on to a tech and to a pharmacist to fill. How the systems process it and take care of it are semantical words.
Mr. Griffey, can you explain the semantical words on that, please, for us? How does that technician pass that on once it's received?
Sure. So for us, order entry and data entry are 2 different things. So order entry is just that. He's starting the order. He's initiating that refill request. He's taking it from the patient. He's telling the system this patient wants a refill, and then he scans his fingerprint, and he's done with it. He has no further interaction with that prescription. He's not making any clinical changes. He's not editing. He's not able to change the drug or the directions, anything like that. That would all be done at a data entry phase, which is required a pharmacy technician, licensed technician to do. So once he took the patient's request of what they wanted, when they wanted it, and that they were approving payment for it, he fingers down, we call it, and electronically passes that prescription on to the licensed staff.
So at no point is it processed. Does it deduct quantity? Does it deduct refill? Does it get sent to a insurance company for adjudication?
Not at his step in it, no.
Okay.
And just to clarify the documents that Mr. Morris provided, what is marked as Mr. Morris's Exhibit D in the supplemental material, this is a new document. So this is an update to your SOPs as a result of this complaint?
Correct. It's going to be more of a, not necessarily a SOP guidance. It's going to be more of a reference for here's what people in these different roles are from a very high level, what they are allowed to do within our pharmacy. So it's not necessarily going to be a new SOP to follow because our SOPs are pretty clear on who can and can't do what. But this is going to be kind of just a collection. It's all in one place to have. Oh, what can a non-licensed tech do? And here's what it is. So it's more of a reference than a policy change.
So the other document that you submitted with the original complaint, and then Mr. Morris also resubmitted as Exhibit C, the job profile for the Associate Pharmacy Care Coordinator number 22. Are you making modifications to that? Because I think that's what where a lot of the concerns come from. There are some duties there that are designated that only a technician or only a pharmacist can perform, and I think that's where a lot of the confusion is coming from here.
Yeah, I would agree. And like I said, I provided that document in error. That is not what we can really consider the job description for these individuals. It's a very high level applying to employees in multiple states, in multiple pharmacy environments. And it's meant to kind of cover it all. Like, here's what everybody in a pharmacy may be doing. But it's still restricted to, we have to abide by the state laws where those individuals are. And they are, again, it's not a description of what each of those individuals is doing. It's more of a job family description. So here's what pharmacy staff, licensed or not, may be doing within Optum. But when you actually are, when that person is actually working, their role is very limited by, like I said, their user role in the system, by the more specific SOPs and procedures that we have for, whatever role they're fulfilling, in this case, customer service.
And your system limits them to what is allowed within the state. So for example, in Arizona, somebody that's not licensed shouldn't be able to enter a prescription for fulfillment. But in, for example, California, where I know you guys have a facility, a non-licensed clerk could enter a prescription. Your system is smart enough to know that based on the jurisdiction for which your pharmacy is located.
We have control over that, yeah. So we
Okay.
would, based on, we only have one location in California, or for our family, pharmacy family, we only have one location in California. So we would make those adjustments to their system.
Mr. Griffey, just a follow-up question for you. It was noted in the case that you had confusion on what the permissible duties of a technician were on the initial visit. Can you comment on that?
Sure. So we used to be Avella, and we were recently acquired by Optum. And this was a misunderstanding on my part of the new job role, job titles. As Avella staff and were being kind of rolled over into the Optum payroll systems and things. They were rolling everybody into under this associate pharmacy care coordinator job role. Again, kind of as a blanket, like, okay, these are pharmacy people, we'll put them under this code. And then, so when Ms. Richardson was on site and we looked up this particular agent, it listed his job code as associate pharmacy care coordinator. And I just looked up that document. And it was just a mistake on my part. I didn't realize that was, again, not the way our HR team has described it to me, is it's not a true job description. I think in the sense of the word that we're using it here, it is more of this kind of overarching job family,
Sure.
all possible responsibilities type thing.
So moving on from the job description itself, were you familiar with the duties that a non-licensed person can perform in a pharmacy? So a clerk,
Yes.
in this case?
Yes, absolutely.
Okay. Board members, any other questions? One comment before more discussion is that the processing of the medication, just forget who did it, without sending the syringes, is not necessarily a error. So I'm not hung up on that. The other thing is Mr. Griffey, pardon me, has gone on record stating that he's aware of the duties that are permissible by a technician and those that are not, and that his system has the ability to prevent any type of processing of a prescription as well. So I am feeling more relaxed on that as well, that there's a common theme that knowledge has taken place or is taking place with a cleaned up job description or the accurate job description, and that the duties of a technician are being completed by licensed people. Now that's my opinion on that, and I'll hand it over to board members.
Mr. President, I tend to agree with you, and this answers all of my concerns. I think that the first part of the complaint was really more of a customer service issue than it was anything. And then as we were investigating it, these additional questions came up. But I feel much more confident in their processes after hearing from Mr. Griffey.
Yeah, I'm willing to make a motion to dismiss as well.
I'll second that.
Thank you, Ms. Snare. I have a motion. I have a second. Any other discussion before a vote? All those in favor? Aye.
Aye.
Any opposed? Okay, thank you for your time today.
Thank you.
Okay, 29E, 2020-27, Fusion IV Pharmaceuticals, Inc., doing business as Axia Pharmaceutical.
Good morning, Mr. President. Steve Hyber,
Good morning.
Compliance Officer, Arizona State Board of Pharmacy. I'll lead it off with just the summary of the overall complaint.
Okay, just
this
real
case,
quick, Steve is the respondent here as well, and then we'll let them speak after you give the summary.
Sure, okay, I'll hang on.
Yes, sir. This is Nancy Swift of the Buckhalter Law Firm in Scottsdale. I'm here on behalf of the respondent, and with me, associated in with me, is Al Mohajirian, and he will be speaking on behalf of our client.
Okay, and real quick, Nancy, you're a licensed attorney in Arizona?
Yes, I am. That's correct.
Thank you. And tell me the credentials of the person that you said was speaking on behalf of Fusion IV Pharmaceuticals.
Al Mohajirian is an attorney, and he's licensed in California. He is not licensed in Arizona, so that's why I'm here. I am supporting him and sponsoring him, and also representing our mutual client, the respondent.
Okay, Nancy, just real quick, let me defer to legal counsel on the ability of him to do that.
Ms. Galvin, we can't hear you.
I apologize. I think it's my headphones. Ms. Swift, the associate you have with you said practices in California. You're here supporting him. Has he been admitted pro hoc vice?
No, there wasn't an opportunity to file a pro hoc vice application. So, but we are sponsoring him, and he's associated in with our firm.
He cannot act as an attorney in this case if he has not been admitted here.
And I'd like to ask that we have.
Ms. Swift, you would have to represent your client.
I do represent my.
No.
I do represent my client. My client is your respondent.
She indicated she does represent her client. They just didn't have an opportunity.
He can't represent her client, the client.
I am representing the client, but he would be speaking. He would be speaking on the client's behalf. But I am here as counsel for the respondent on the record.
Technical issues. Ms. Swift, are you able to hear me?
I can hear you now, yes.
Sorry, Mr. President.
Here.
I'm sorry, is someone speaking? I can't hear. I can't hear.
Ms.
anything.
Swift, we're having technical difficulties. We're just
I don't know
working
why
through
you
them right
can't
now.
hear.
Give us a few minutes, please.
Sure.
My speakers are. Can you hear me now, Cam?
Yes.
No. I'm going to leave the meeting and come back in. Seth can take over, obviously, until I can come back in.
Sure. Mr. Hargraves, are you available?
Okay. Can you hear me now?
We can hear you. Can you hear us, Ms. Galvin?
Yes.
Perfect.
My comment from earlier was that while Ms. Swift is admitted to the Arizona bar and is able to practice in the state, the individual that is in her office also seeking to represent the client is not licensed in the state and would not be able to appear on behalf of the client in a legal capacity without being admitted to the State Bar of Arizona.
Then I ask, would it be possible to either make an oral motion today that Mr. I'm sorry, I'm a little befuddled at the moment. Would it be possible to either make an oral motion that Mr. Mohajirian be admitted pro hoc, or that he be allowed to speak not as an attorney, or as a third option that we continue this briefly so that we can get him admitted pro hoc vice. I looked through the your regulations and I did not see a specific procedure such as there is with the court system. And since we were recently retained, there really wasn't an opportunity to do an application like I would do with the court. So perhaps one of those three options would be acceptable to the board.
The court rules regarding admission provide for admission before an administrative body. So that is the same process that this agency uses. If you feel that he can provide information, not as an attorney on behalf of your client, then you are free to proceed that way.
I'm going to ask him if that would be acceptable. The information, because I understand this is a conference and not a hearing. So if he provides information today, not as an attorney, I assume it's information that the board would still consider and give it the weight that it would deserve.
May I add a comment here?
Yeah, please.
Thank you, everybody. Well, I'm not eyewitness here. I'm counsel for Fusion. I'm counsel on the record for federal court. We have a writ of certiorari before the Supreme Court. So, I can't waive attorney-client communication privileges by wearing a hat of a witness, unfortunately. So I have to remain as counsel. Since our communication, I tried to retain local counsel as we did, and we are in process of submitting pro hoc vice. Unfortunately, because of the COVID issues, obtaining a good standing ruling from our state board and submitting it to the Arizona State Board is taking a little longer than it needs to be. I don't know if you guys know, but even the California State Bar is being evicted from their space because they didn't pay rent. So there's a lot of commotion. It's in the news. And they may even file for Chapter 11, it sounds like. So we don't know. But albeit because of the COVID and because of these commotions, it's taking a little longer. But I'm confident if you continue this motion, this hearing maybe for 6 weeks, we should be able to have a pro hoc vice circulated. The papers are already done. We have made a request for a good standing letter that Arizona Bar requires to our state bar, but we haven't heard back yet. So really, we've been really working hard since I've been put on notice to not only retain local counsel, but also submit pro hoc vice. And that's why I asked Ms. Swift to appear with me today, because I realized that pro hoc vice application wasn't fully completed. So I thought it's best to have all on the phone. But albeit, I think what I could offer, which I did, I copied your offices with the writ that we have before the Supreme Court that has to do with exclusivity issues and jurisdictional issues and the application of state law issues. So I think I should be able to offer help with understanding the process, but because of the fear of wearing a witness hat, I may be waiving attorney-client communication privileges, so I'm not comfortable testifying as a witness, so I have to speak as an attorney. So with that said, I think between now and the next 6-7 weeks, what I would be able to offer, I think is tremendous and will be helpful.
Mr. President, I would ask the board to consider their motion to continue this matter until proper admission is obtained.
I appreciate
Okay. Board members?
Yeah, I have no objection to that, Mr. President. If it's possible, I'd like to make the motion to continue the matter till the next board meeting, which should give them adequate time to do whatever they need to do on the legal standpoint.
Thank you.
Okay.
Okay.
Okay, I have a motion. I have a second. Any other discussion before vote?
Mr. President, the only concern currently is there was a cease and desist, I believe, issued. And I'm not sure if they are shipping into Arizona at this time.
Ms. Swift, can you answer that question?
I do not believe they are shipping into Arizona at this time. Mr. Mohajirian, is that correct?
I think Dr. Vahidi is on the conference too. I have to double check with him. Dr. Vahidi, are you on? Do you hear us? Can you provide an answer?
Yeah, I'm here. We've halted until further
decision
direction from the board.
Thank you. Mr. Vahadi, may I have you go on record, please, and state that you will not ship until the next board meeting when we hear this?
Sure. Well, you just like me to say that we will not ship until the next hearing.
Until we have a resolution to this case.
Until we have a resolution to this case.
Okay, thank you. That is received and on the record. Board members, we have a motion and we have a second. I will defer to legal staff one more time before I move on to a final vote. All those in favor?
Aye.
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 Any opposed? Okay, thank you for your time today.
Thank you, sir.
Thank you.
Okay, thank you.
Okay. Cam, where are we headed next on the agenda?
Next on the agenda, Mr. President, would be special request, number
Okay.
33. So we would be on 33A.
Thank you. Okay. 33A, this is discussion and consideration and possible action regarding Ashley Dare Reese. I'll defer to board staff if Ms. Reese is present as well. Can you identify yourself?
Mr. President, I do not see Ms. Reese in our meeting.
May I ask, is Ms. Fine in the room as well?
Yes, I'm here.
And I know I'm putting you on the spot, but you have a letter of support for this individual as well?
Yes. She is out of state, and so I'm wondering if she's confused with the time zone. I was going to message her real quick, but yes, I did submit a letter of support. She actually completed technically by date a while back. And so she's been continuing to participate until she could appear.
Okay, thank you. Board members looking at this case and looking at the completion of the terms and hearing the support of Dr. Fine, I'm willing to move forward with this. If you are not comfortable with that, I appreciate if you would state that. If you have a different view, it's time to discuss that as well.
No, I agree with you, sir. We have the letter from North Carolina Board of Pharmacy confirming that she's completed it. Whatever she needed to complete. Ms. Fine has supported her, so I think we're good. Do you want me to make the motion? Oh,
thank you, Mr. Slary.
I'll make a motion to grant the special request and release Ms. Reese from her probation.
Second.
Okay, thank you. I have a motion and I have a second. All those in favor?
Aye.
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 Any opposed? Okay, thank you. 33B, Teresa Ramirez.
Hi, yes, President Teresa Ramirez.
Good afternoon. How are you?
I'm doing great.
Good. Thank you for joining us today. Tell us a little bit about the special request before us today.
So my license has been suspended for quite some time due to substance abuse, and I've been participating with the PAPA program now for, I believe, a little over 12, I think it's about 15 months. And I'm doing all the things that are required of me to participate in my recovery, and not just to participate in my recovery anymore, or what's required of me to participate in my recovery. I'm doing more, but for myself, for my immediate self, not just because it's a requirement anymore. I participate in my IOP class through the PAPA program, but I also am very active in my 12-step program that I'm working. I have a sponsor. I'm currently doing step work. I got on the Crystal Meth Board Association for information and outreach to the public, and I've helped sponsor and put on a few different events. For instance, a Halloween event. We haven't been able to coordinate many other events with COVID still the way it is. But I also have gotten involved in a little bit of H&I, just sharing my story, giving others encouragement, strength, and hope. And I really love my life now. So I'm asking for my license to be, the suspension to be lifted. And I thank you guys for allowing me to be part of the PAPA program so I can work to get my license in a good standing status again.
Thank you, Ms. Ramirez, and congratulations on your journey. Board
Thank you.
members?
Again, Ms. Ramirez, thank you for sharing your story and congratulations on your participation with the program. Given Ms. Fine's letter of support and her compliance with the program, I would be willing to make a motion to grant her request to lift the suspension from her license.
Second.
Okay, thank you. I have a motion and a second. Before a vote, I'll defer to legal counsel.
Members of the board, are you going to require any probationary period?
We typically do we not, Jane?
Typically, yes. It's usually and followed by a term of probation that's deemed appropriate based on recommendations from those who've been monitoring her. I don't have the exact dates, how long she's been on suspension, but the entire period typically runs 5 years.
Board members, I do think that we should progress to our natural procedure. And she is coming off suspension and making really good progress. So the next step in our standard agreements would be the 5 years probation.
And President Leba, this is Seth. I believe our agreement is in the board packet, which includes a suspension and probation.
Right.
Page 2407. So it sounds like she may just continue on with the provisions of the current agreement.
That's what I thought my understanding would be, that I would continue on staying with the proper program.
Okay, very good. Thank you.
Okay, thank you for clearing that up.
Ms. Galvin, is my motion appropriate then, given the way that the consent agreement is written?
I would add that you are lifting the suspension and that respondent will continue to comply with the order that's in place.
Okay, thank you. So I'll amend my motion to lift the suspension and allow Ms. Ramirez to continue on with her consent agreement and probation as listed in her original consent agreement.
Amended second.
Okay, I have a motion. I have a second. All those in favor?
Aye.
Aye.
Any opposed? Okay, thank you for your time today.
Thank you.
33C, this is for Shahzad Salahi. If I could defer to board staff to start us here and just make sure that the individual is not in the room, then we can get going on the discussion.
No, Mr. President, I do not see her in our meeting room. But upon Ms. Aleje's request, we had agendized this as she was contesting the civil penalty that the board issued regarding her continuing education.
Jennifer, can you confirm that the CE that she completed did she turn additional CE in after it had been brought to the board's attention?
Let me confirm that for you.
Because I've not seen what it is that we're looking to change, or what would change it with what's before us. If she came forward and said, oh, look, I found all these CE, I just didn't submit them, then I would look at it. But that's not what I think is happening.
not appear that any additional CE was completed.
And the individual was still deficient. That stands, right, correct? So in my opinion, if the consent agreement is not being signed, then we move to hearing, and in here, the individual requested a hearing as well.
I agree. I don't think there's any new evidence here that would make us reconsider it.
Okay, my recommendation and motion team would be to move this case to hearing.
Second.
I have a motion and a second. All those in favor?
Aye.
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 Any opposed?
Mr. President, just one question, please, if I may.
Absolutely.
If she signs the agreement and agrees to it, the consent agreement as proposed, would you allow us not to move it to hearing? As your motion is move it to hearing, then we have to go through the vacate process.
So part of what I said that was she's requesting it in here as well, but when was the consent issued to her? How long has it been since? If this continues, then if we're going to go that route, I would say if not signed within 30 days, move to hearing. And I would amend my motion for that.
It appears that the consent agreement was initially sent to her, offered November 9th.
Yes, correct.
So we have had plenty of time to sign that consent agreement, but I am willing to amend my motion to allow for 30 more days to sign the consent agreement or move to hearing.
30 days to sign the consent agreement and comply.
Yes.
I'll amend my second.
Any other discussion, board members?
I would like to add something, please.
Yes.
Ms. Salehi did provide additional, she, with her audit, provided CE that was completed after her renewal date. So I can clarify that, but that CE did not count towards the audit period.
And in speculation, if that was the basis for her today to be on here, then it doesn't change anything.
Yeah, Mr. President, my problem with these things is that these individuals upon renewal certify yes on their renewal application that they've completed the CE requirement when they haven't. And that's the part that I have a problem with. So if the fact that she completed the CE after the end of the period doesn't fix it the way I look at it.
Nor does it for me, Mo. You're right. So any more discussion before we have the motion and we have the second? Okay, all those in favor? Aye.
Aye.
Any opposed? Okay, thank you. 33D, Alicia M. Boyce.
Mr. Boson, we cannot hear you, sir.
Mark Boson, counsel for Alicia Boyce. Alicia Boyce is also present.
Okay, thank you. Would you tell us a little bit about your special request before the board today?
Yes. I'm here today, as you know, on behalf of Alicia Boyce. This board knows me well. I present to you often on a number of different matters. As a member of the pharmacy profession and the bar, I am proud of my reputation that I hear from public officials that often describe me as someone who is reasonable and fair. I do very much, as an officer of the court and as a member of profession, try to recognize both sides. And in this issue, I understand the side of the board. The board has said, hey, you needed to complete 30 CEs within a certain period of time. You attested to that on a renewal application, and that renewal application referenced the rule by citation. Alicia Boyce is a good pharmacist. She's been a pharmacist for 21 years with an unblemished record. when she completed her renewal application, she completed it with the impression that the 2 years was a calendar year cycle. She was wrong. She comes from Illinois. Illinois is a calendar year cycle. Therefore, she got off track. And for that, you will hear from her that she is sorry for that. This is the first time she's ever been in trouble. And as I said, to date has had an unblemished record. Despite the fact that Alicia got off track with maintaining compliance with her CE, I fear that this case has also gotten off track from the board's perspective. For a first offense, for someone who committed something related to compliance with CE, you are proposing a $1,175 fine, 15 extra hours of disciplinary CE, and a mandatory re-audit, which would also be considered disciplinary. Find that to be rather draconian. Why? At the root, the board has a mission to protect the public. One of the things that I tried to do to prepare for this case was understand, does CE do anything that relates to a measure of a health professional's competence to practice? And what I found was a glut of information that says there is no information, no study that's ever shown any compelling evidence that participation in CE and compliance with CE has anything to do with a health professional's competency or safety. In fact, I can read from you a 2006 article written by a healthcare management organization that says, although most states in the United States require healthcare professionals to complete continuing education units for licensure renewal, little evidence to date has established a relationship between completing CEUs and clinical competency. Considering the high cost of healthcare delivery and services, it would be prudent for both managers and consumers of healthcare to review costs and benefits of requiring CEUs, including the cost to this committee, for professional licensing renewal. This study features an extensive review of the literature to analyze the supportive as well as the opposing views on mandatory CEUs for professional license renewal. Most of the studies reviewed reported almost no relationship between participation in traditional continuing education courses and improved patient outcomes. That's a quote. I understand, though, that you have a grid. I would argue that the grid that describes certain penalties that members of this board has often referred to as mandatory was not developed by any statute or any rulemaking process. It is simply an internal guide that is used for the board. What is striking about this guide that has March 2019 at the top of it, it's a guide that's entitled Complaint and Application Guide. It's a one-page document. Almost 25% of the top of this document talks about failure to complete CEs, and it talks about it first. There are lots and lots of things that you expect to do if someone fails to complete CEs. But if you scroll down to the bottom, the third item, which is called criminal background, there are a number of things that you recommend no action be taken. One of those is striking to me as someone who is a pharmacist and addiction medicine specialist. A single DUI that is recent and has no drug involvement requires no action by this board. If there was anything on this list that would be a red flag to me as a regulator, that someone might be a danger to the public, it would be someone who was arrested for a DUI. They
Mr.
might not
Bozen,
be.
I want to stop you there. That grid, that is if they disclosed it, a single DUI. So that is the element of honesty was maintained with the board. In this case, we have an element of dishonesty with the board saying that she did something that she didn't. You can go ahead and proceed, but I just wanted to stop you and let you know that that's what you're saying is not entirely accurate.
I respect your comments and will consider them in our discussion. Let's say for sake of argument that you still take no action for someone who's reported a single DUI. Why that doesn't cause the board to take pause and say perhaps this person may want to be evaluated by a substance use professional to see if they do potentially have a problem that this board would want to look at. I will go to, and it will be uncontroverted, that your job is to protect the public. If there's nothing in the literature that describes the benefit to the public of a pharmacist completing mandatory CEs, and I will note that in this state, nurses have 0 CE requirements to renew their licenses. That board has taken a look at the issue and said there really isn't any value to this board to require it. Then why wouldn't you take a look at something that would relate to the use of a substance, alcohol, in an inappropriate way to at least investigate any further? Here's why we're here today. You've got a pharmacist who's got 21 years of an unblemished record. You will hear from her that her quote unquote dishonest representation on her application was an innocent mistake. She was under the impression, because of her history, and she will admit that she was wrong, that she thought it was a January to December cycle, 24 months. It did occur to her that it was an October to September cycle. Upon reflection and communication with the board and me, she understood, and it makes more sense now, but she did not purposely and with intention intend to deceive this board. We believe a reasonable outcome, and frankly, if I may be so bold as to recommend changes to your grid, is for a first offense, you have the option as the board, under statute and regulation, to issue non-disciplinary CE. I would argue that it would be a fair outcome in the interest of justice to require several elements on your grid, but in a non-disciplinary manner, because this is her first offense, and she will admit on the record that it was an innocent mistake. And that is 15 hours of extra non-disciplinary CE that will be reported in addition to her 30 required hours of CE at her next renewal cycle. You have that ability to do that. You do that frequently with patient safety issues. You will recognize that pharmacists who made innocent mistakes and dispensing errors have been issued non-disciplinary CE. There's no allegation that she's been a danger to the public. There's been no allegation that she's done anything other than make an innocent mistake on a renewal application. And with that, I informed my client she's very, very nervous that you will probably have some questions for her, and she's available for your questions, and I'm also available for your questions.
Mr. President, this is Kevin Deng. I have a question for Ms. Boyce.
Let's do a introduction and opening statement, and then as soon as she's done, we'll come directly to you if that's okay.
Okay, sure, yes, thank you.
Hi.
Hi, Ms. Boyce. Welcome to the meeting. Yep, I'm glad you're here. I don't want you to feel nervous. Just take this as a time to communicate with us, and I'll let you go whenever you're ready.
Okay. I did my CEs as I thought under the proper requirements. I, pace myself throughout the year and I do my CEs. And when I had completed them, I checked the box, paid my renewal fee, and sent in my renewal information. I was not aware that I was off track. I checked that box with full intent of honesty that I did my CEs appropriately within the appropriate time frame, being, based on having always done my CEs under the Illinois statute at first of the year. So I did the same thing, and I wasn't aware that I was off track. And there was no intent of any dishonesty or deceitfulness in doing that. I am really sorry that I did that. Wasn't aware. And, my goal and my intention is to make sure that I do the proper renewal period on a rolling calendar and not a first of the year calendar, now that I had been educated and advised as such. But it was never a malicious, willful intent to deceive the board to not do it properly.
Okay, thank you. Mr. Deng?
Yes, so Ms. Boyce, which other states are you currently licensed in? Besides Arizona and Illinois?
That's it. I don't work anyplace else.
How many years have you been practicing as a pharmacist?
It'll be 21 years.
21 years. Are you currently sign up with the pharmacist letter online?
I do most of my CEs through going through conferences. I like to attend conferences. I do online free CEs through, what is it called? Forgot what it is. It's the free one. Some Pharmacy Times, literature stuff. I do online web-based CEs as well as attend conferences. I like to go to conferences because you get a lot more CEs done at one time.
Okay. The reason I mentioned pharmacist letter is because I have multiple licenses myself too, and pharmacist letter has a very unique tools that it helps us keep track of the dates that are the requirement dates for CE completion for each state. So one thing that I need you to help me understand is being practicing as a pharmacist for 21 years, and you know that the law, each state has its own dates, if you would, the CE requirement dates. For example, some state would go by your birthday, some state would go by the calendar year, some state would go, like our state, Arizona, go by October 31st. I think it is, and I am a firm believer that it is a pharmacist's responsibility to make sure that you keep track of those dates. And those dates are specifically listed on the law book. Before any student, any pharmacist who want to obtain a pharmacist license, each and every one of us have to read the law book, and we have to make sure that we know the dates. And to my knowledge, after taking the MPJ for 9 other states, those questions are always on the law exam. So it's hard for me to believe that you're not aware of our requirement.
The licensure CEs that I would do for Illinois versus Arizona, they would overlap. So part of the CEs I would do for Illinois would hold for Arizona because of the time period in which I transferred my license here when I moved here. So that's why I thought I was on calendar year and why, you know, I wasn't cognizant to that, in all honesty.
Mr. President, if I may, Mr. Boson, you indicated that Illinois is on a calendar year cycle for CEs.
Yes, Alicia, is it correct that you renew every January 1st for Illinois? Alicia,
She's thinking about it. I'm licensed in Illinois as well, Mr. Boson, and my renewal doesn't take place till the end of March is when my license expires in Illinois. I'm also on the Illinois Board of Pharmacy's website, fact sheet on CEs. And the CE requirement of Illinois is 30 hours of continuing education every 2-year license cycle, which will be from March to March.
In fairness, in preparation for this hearing, I looked at the Illinois Board website and found a piece of information that may or may not be accurate, that licenses are generally due on January 1st. And it doesn't surprise me, though, that I may have been looking at the wrong section. And but if she was compliant with Illinois, she still might not be compliant with Arizona. And I think that's the point we're trying to make, is that there's no allegation of patient safety here, that there was any harm. There is an allegation of deceitfulness. Deceitfulness requires 2 elements. One is intent, and the second one is an act. And she's testifying that she had no intent to be deceitful. She thought she was compliant. Believe me, we have had extensive discussions and tools. And in fact, one of the tools I would recommend is the NABP CPE monitor that allows you for a fee to track multiple licenses, and it gives you a green or a red indicator whether or not you're compliant. I have licenses in 27 states. Believe me, that CPE monitor comes in very handy, because not only do I have to keep track of the times, the dates, but I also got to keep track of all of the extra things that you do. Florida requires CEs, for example, that are not ACPE accredited, but are issued in compliance with board approval, and it is a hodgepodge of incredible administrative burden to manage multiple licenses. In 1995, I participated in the Pew Health Professions Commission that said, hey, a part of what's a problem with all of the health professions is we've got this hodgepodge of 50 state licensure and different rules for everyone. I'd go back to our contention that there is a more fair and reasonable outcome. And my concern is you're going to go back to the grid and you're going to say, I want to treat everyone fairly. And the point is every case is a little bit different. And I think this case deserves some extra attention because you've ended up with a draconian outcome that I don't think more reasonable people looking in think this is fair at all. There are people who have put patients in harm's way who haven't received this level of discipline. And with the job market the way it is, anyone with a small amount of discipline is going to have a very, very hard time moving forward with their careers. And but for this oversight, which she immediately corrected by getting the CEs, and that's another issue. Once you've missed that deadline, you can't correct it. But once she did learn of her lack of compliance, she caught up on all of her CEs. And part of our response was, here are the CEs that we did post-cycle November, and she promises not to use those toward the next 30. We also thought that was a fair way to deal with it because there was no way to go back in time and fix it. She could only deal with going forward, and she did that proactively without request and with a signed sworn affidavit that said, I'm not going to use these toward the 30 next year. I just don't know any other way to handle it. As a matter of public policy, the grid concerns me because it doesn't allow the board its ability to look at each case one at a time. And Alicia is going to have a hard time, according to her, affording this $1,175. And frankly, we agreed to take this case at no charge because we think it's critical, not just for her case, but cases that come forward. And I would hope you give her some consideration of fairness and justice. There's got to be a middle ground here that is short of $1,175, 15 disciplinary CEs, and a mandatory re-audit. 3 types of discipline for one act that is administrative in nature and had nothing to do with patient care.
President, may I ask Ms. Boyce a question?
Mm-hmm.
Ms. Boyce, how many years have you held an Arizona license? I didn't see it in the materials.
I moved here February of 2011 to be close to family.
So you've been practicing with Arizona license since then?
Yeah, since February 2011.
Thank you.
So during that time, were you in compliance with your CEs or you've been out of compliance?
I thought I was, yes. I've always done my 30 plus CEs every year. I've never not done my CEs. It's just I was doing them dated wrong.
Ms. Kiana Vong, can you confirm if she's ever undergone a CE audit in Arizona, or is this her first?
Based on our records, this appears to be the first.
Mr. President, I'd like to make a motion for executive session for the purposes of legal advice.
Okay. Mr. Dang, did I see you second? You were on mute.
Yes, second.
Okay, so I have a motion, I have a second. All those in favor?
Aye.
Aye. Any opposed? Okay, Ms. Boyce, we're going to seek legal advice in a private session, and then we're going to exit this room and we'll return back to it.
I have a comment. Mr. Bozen, I feel like you stated something in opposition of what your first statement was. You said that our grid was meant as something we can go by and don't have to stick to. And then later, I feel like you said something to the point of this grid is shouldn't be used, or you have to stick with it. So I just want to make the statement. It was meant so we can stay consistent with how we handle cases and not be arbitrary. It wasn't from 2019, I believe it was from 2016. And that grid was updated to include the other items below regarding like the DUI and et cetera from 2019. And I think that your information regarding CE may be a reputable source, but I feel like we could also find sources that would back the importance of CE. So I don't see that as necessarily a factor that we need to weigh out on whether or not it was answered affirmatively that the rules were followed in this state. So I think that my opinion is more to the point that we should stay with being consistent as we have in the past, and to continue with what we've already put forward for Ms. Boyce.
And just an additional point, Mr. Bowen, if you don't mind. While I understand and appreciate the challenges with being licensed in multiple jurisdictions, I am as well, in the fact that it is confusing. It be what it may, and there are tools out there to help track pharmacists track to make sure that they're compliant with the CE standards. Ms. Boyce is not a newly licensed pharmacist in Arizona. And while I agree we need to look at the unique circumstances that appear for each and every case, under ARS 32-1937, the statute, it states that the board may consider exceptions from the requirements in an emergency or hardship cases, or for good cause shown by written request for an exemption from this requirement. I haven't seen anything that has been presented by you, Mr. Bozen, or by Ms. Boyce, other than the fact that she simply just didn't know that the timeframes didn't match up. So while I'm understanding of the circumstances, I really don't feel like this is any different than any other situation that we've had in the past, unfortunately.
Mr. President, I'd like to offer a rebuttal if it's within your permission.
Sure, go ahead.
Just to everyone's point, I understand the grid, and I understand the intent behind the grid, and that is to prevent the board from being arbitrary, which I think is an important public policy piece. We are also not presenting evidence that we think absolves the respondent from her responsibility. We are simply arguing that the level of discipline is inconsistent with other issues that have faced this board, and the grid has led you astray in this instant. And what we are admitting to is that, yes, she deserves some sort of next step. You have an option as the board. You have full discretion over the amount of discipline that you inflict, including issuing non-disciplinary CE. We are requesting non-disciplinary outcome because we think it is reasonable and just and consistent with other uses of non-disciplinary CE that have been used for patients that have been put in harm's way. And we think there's a mismatch. We're not asking you to absolve her of her sins. She's fully admitting to them, but it's the level of discipline. We think it's draconian, particularly since it has nothing to do with patient harm. And I would also challenge Board Member Sneer's point that there must be data out there that supports the use of mandatory CE, and I would challenge the board to find that and present that as evidence because there is a dearth of information, and at best, the information that we've been able to uncover says there is little evidence that it has anything to do with core competency.
Thank you, Mr. Bozen. Board members?
May I make a statement, sir?
Yes.
So, there's a lot of things that I have sympathy for both Ms. Boyce and there's a lot of things Mr. Bozen said that I agree with. It's not that the board isn't aware that some of the disciplinary issues here are a little strict. Senate Bill 1087, page 24, item C, we are working on making CE violations a non-disciplinary issue, and we have to wait for that to go through the legislature. So that's coming. Unfortunately, Ms. Boyce's timing is off a little bit, and if this case had been discovered later, it might have a different outcome. But we have to treat everybody the same. We can't have previous case or those pending in front of us come back and say, well, how come you let her off? I deserve the same thing. I didn't know either. So while I'm sympathetic here, I'm unlikely to need to change with, I guess, what's the right word? Deviate from the grid, because it would just bring an avalanche of cases back, and we can't have that.
Mr. President, may I?
Yes.
If it is the board's bill before the legislature that this be considered non-disciplinary, then that is further evidence that you agree to some extent with our point of view. And if your direction to us is go seek an amendment to 1087 that would make this non-disciplinary and expunge all previous discipline that's been issued because but for your hands were tied, we're happy to do that. And with that, we'd request a postponement until after the state legislature table this issue until the legislature's met and see if the state legislature that has public policy making authority agrees with that position. And if they do, let's reconsider it in the light of a newly passed law.
Thank you, Mr. Bozen. And that I do want to remind you that was Mr. Solari's opinion that this would have been a non-disciplinary CE. That's not, it hasn't been decided as a board, but that is the option in that bill for a non-disciplinary CE.
And to that point, that's my motion now. Would the board consider tabling this issue until the end of the legislative session?
Yes, I am not in favor of that, board members. I think we've heard opinions and we have given this a lot of time, and it's time to make a motion and move forward. I think that Ms. Boyce, you made a mistake, and it was a mistake. That's how that was. It is still something that you've been in Arizona for a very long time, and you know the requirements of CE, and you didn't document truthfully, even if it was a mistake on the renewal. And we have a lot of that, and we have a lot of those stories with this board. So not saying you're a bad person, I'm saying that there was an error of judgment there. Board members, I'd open it up for you.
I echo what you say. I have a lot of empathy for your position, Ms. Boyce, and at some point, maybe we could look at our grid, but I think to be consistent, we should stick with what we've got here.
Mr. President, can you hear me or not?
I hear you.
You know, all the time when we have these kind of cases, when we find new information or whatever, we table it and let the rest of the information come. If he wants that as an option, I would actually be in favor of letting him table it.
Mr. Minkus, there's no new information here. This was based off opinion on a bill that's being run for non-disciplinary CE in the future. There's nothing changed with our approach here. There's nothing changed with our statute. Ms. Walmsley re-outlined the exceptions to it, and that there's nothing there.
This is Goodman. I'm of the belief we need to follow the laws and rules that exist as they are, not what they might become in some future date, independent of our own desire.
I would agree with that.
I just want to clarify that when
the motion included an intent to amend Senate Bill 1087 that would change the law in a way that would allow it to be issued retroactively. And that's the new piece of information that was part of my motion.
I just wanted to clarify that when I brought the Senate bill up, it wasn't to it was with the intention to say we're aware of the shortcomings of our system and we're trying to fix it, not to give you an option out to wait us out.
And to that end, the CE requirements are in statute. And Mr. Boson, you mentioned that, the legislative body makes the rules to determine, what is appropriate in this case. And the legislative body has stated that they find value in CE. And I don't know that that's our job to overrule that at this point in time.
Ms. Walmsley, was that the beginning of a motion?
Mr. President Laibach, I think Mr. Boson wants to speak.
I'm not sure he can hear.
I haven't been able to hear for a couple minutes now when Lori started talking. Can you hear me now?
Yes.
I'm sorry, Lori, I missed everything you said.
I mentioned that related to the CE requirement that it's in statute and that it's really not our place to determine the merits of that requirement, and that's set forth by the legislating body. So whether or not CE has merit or not, I don't know that that's the discussion that the board is able to have today.
My point is not to change the requirement on CE, just the discipline that you're proposing. You're proposing almost $1,200 in discipline for this. That's all we're arguing. We're not arguing that the CE didn't get done, just the level of discipline is draconian based upon the grid that has no basis in statute or rule, just to clarify.
Thank you for your opinion, Mr. Boson. Board members? Mr. Tong, did I have a motion?
I move to deny the request.
Okay, I have a motion by Mr. Tong. I have a second by Mr. Dang. All those in favor?
Well,
I'm sorry.
would that include, Mr. President?
I'm sorry.
Did you have a question?
Would the motion include reoffering the respondent the consent agreement within a certain time to sign? And if she doesn't sign, go to formal hearing?
Mr. Tong, is that something you'd be interested in amending your motion to?
No, I'm not. I just deny the request for reconsideration.
Okay, when was the consent offered? And from the time the consent was offered, what was the time on it? 90 days? I don't recall.
It's usually 30.
Okay.
Jennifer's looking.
Okay. So we still have a motion. If it's not signed within the 30 days, it'll come back before us.
Yeah.
I'm sure it was more than 30 days ago.
When is the payment of the fine? Is that also within 30 days?
So a response to the consent agreement was due on December 23rd, 2020. The payment of the fine.
90 days, line 22, page 2466.
Thank you.
Mr. Tong, I would encourage you to amend your motion to include the signing of the consent, if not to move to hearing, because it is basically what we do in our standard approach with everything else.
I agree. Thank you for clarifying. Yeah,
okay.
I agree.
So I have a amended motion.
I amend my second.
And I've amended second. All those in favor?
Aye.
Aye. Any opposed?
Aye.
Okay, thank you for your time today.
Thank you.
Okay, well, let's take a quick 10-minute break and then we'll come back and we have one more case and we have a call to the public, but I want to allow for a quick break. Okay, welcome back, team. Before we get rolling on our last couple topics, we'll have Dr. Gandhi do a roll call.
Mr. Solari.
At your service.
Mr. Dang.
I'm here.
Mr. Minkus.
Here.
Mr. Leba.
Here.
Ms. Lahan.
Here.
Ms. Walmsley.
Here.
Mr. Tong.
Here.
Mr. Goodman? Mr. Goodman? Ms. Nair?
Here.
Okay, I'll keep an eye out for Mr. Goodman.
Looking at the agenda under special requests, we have 33I.
Mr. President, I'm recused from this item due to my employment.
Okay, thank you, Ms. Walmsley. This is a request to deviate Walgreens Central Fill number 0301312, pharmacy permit number Y008558.
Mr. Leba, Roger Morris, Quarles and Brady on behalf of Walgreens.
Okay, welcome.
Can we make sure the other three members are on, and then I'll do the introduction? Is Matt Cook on?
Yes, Roger, I'm on.
Alicia Lesher
I am also on.
and Mike Stimco? Thought I saw Mike on the list.
Mike is on, but we can't hear him. So I do see him that he's joined the meeting.
Okay. I think we can get started. He can shoot me a note if he needs to say something, but he was supposed to also be available. Okay.
Roger, before you get started, just for the record, Mr. President, Mr. Goodman is on as well.
Okay, thank you.
I'm on. Can you hear me now?
Yes, we got you, Mr. Goodman. Thank you.
And Mike Simcoe.
Terrific. Okay, we've got everybody then. This is a request by Walgreens for their new central fill facility down in Tolleson, Arizona, that is anticipated to open in April, May of this year. The board has already approved the permit for that facility, subject to your compliance officer's inspections. What we're asking for is a deviation to ARS 23402A11, which is the final pharmacist check. This is using updated technology that the board is familiar with. In fact, the board has approved this technology for Walgreens in the past, has approved it for other pharmacies in the past, where the final pharmacist verification takes place at the loading of the canisters in the machine. The machines don't make mistakes. They always get the right pills into the right bottle. So the issue is that the final verification by the pharmacist would occur at the loading of the canister stage rather than in the filled pill stage that's there. I'm going to have Mr. Cook explain to you the process, what safeguards there are in it, and the system in the pharmacy itself. So I'll ask you to talk about the technology, and Mr. Simcoe, if anything else comes up. Mr. Cook?
Thank you, Roger. Can everyone hear me?
Yes.
All right, perfect. Good morning. My name is Matt Cook. I'm a Senior Director of Centralized Services for Walgreens. I'm a pharmacist. I spent many years practicing in Arizona. Good to see many of you again. Now been in Illinois for 7 years, and it's snowing here. I can tell you, I enjoy Arizona much more. I've been with Walgreens for 25 years, and I'm now leading the program to enable the rollout of our central fulfillment capabilities. We do have the license application pending final inspection for a new closed-door central pharmacy that will assist pharmacists in filling prescriptions for Walgreens pharmacies. We've also made an investment in Innovation Associates to secure a long-term partnership. As Roger indicated, I have Alicia Leisure here from Innovation Associates with me to help answer more technical questions about the Symphony operating system, as well as the equipment that we will be using. But first, a bit about the facility. This is a closed-door pharmacy that is highly automated, highly efficient, high quality, and it's designed with a combination of robotic automation and software to take the product fulfillment volume out of Walgreens retail pharmacies and provide pharmacists and technicians time for critical clinical activities such as COVID vaccinations and things of that nature. Roger indicated we are here today requesting the board approval for a deviation similar to other pharmacies in Arizona to implement a technology solution that enables the quality patient outcomes by using a closed-looped system of upfront pharmacist verification versus visual inspection of a single product vial at a time. Outside of Walgreens, an interesting fact here is that there are 10 sites across the US utilizing this closed loop canister verification under the guidance of the Symphony software. And in the past year, this technology has allowed over 27 million automated prescriptions to be filled with no prescription fulfillment errors. So we'll talk more about that in a minute, but I also wanted to make you aware while we're here of the scan-to-scan process that we will be using that complies with Rule R4 231104.1 that allows the technician to perform final product verification for unit of use products. We will also leverage the process reengineering within the Symphony system that results in getting the right prescription to the right patient at the right time by using scan-to-scan processes that is automated in nature with safeguards designed to allow correct labeling. Obviously, we will meet also the other eligibility requirements with technician certification, hours worked, training, and CE that are also called out in those rules. But with these innovations, we really are aligned with the mission of the board to protect the health, safety, and the welfare of the residents of Arizona via the distribution of the correct prescription medications on time to patients. For now, I want to focus on the canister verification approach. The approach that we are taking allows the pharmacist to verify replenishment of canisters in place of the traditional prescription visual inspection. I did include a picture of the canisters in the presentation material for your reference. That may be helpful as we walk through the process that we're proposing to use. But I'd like at this time to turn it over to Alicia Leisure to walk through the canister filling process, and then certainly we'll open it up for any questions.
Thank you, Matt, and thank you, members of the board, for having me here today. I'm Alicia Leisure, Executive Vice President of Enterprise Architecture and Software Engineering at Innovation Associates, also known as Chief Engineer, a much shorter title. I've been part of the IA team for the last 20 years and closely involved with developing automated solutions for over 2,500 pharmacies worldwide, including 40 of similar size to the Walgreens Arizona facility, and the largest of which is a VA CMOP capable of filling over 200,000 prescriptions per day. In each of these solutions, our hardware integrated with our Symphony software platform drives that quality throughout the fulfillment process, as Matt discussed. In this particular facility, counting automation will be responsible for filling approximately 80% of all medications. This technology is made up of individually assigned counting devices that are replenished through secure canisters filled in, as Matt said, a closed loop software guided process. We call it a closed loop system because once the canister is sealed, there is no human access to the medication, drastically increasing the quality of the entire tablet and capsule dispensing process. So in addition to the materials provided, I wanted to take a moment to highlight a few key technical points that help this canister replenishment and verification process. And through this, you'll see the different points of quality that are built into the process. At the start of the process, the canister and dispensers are assigned an 11-digit specific NDC. This occurs through an NDC and serial number scan process, which is validated by a pharmacist and electronically stored in both the canister and dispenser's internal memory. Only a pharmacist can change this assignment, either through an unassignment or reassignment process, to a drug of a similar category. Canister filling itself is initiated by the software only after the canister is electronically connected to the computer via a docking station. It is then that only the same 11-digit NDC assigned to the canister can be scanned. Scanning is required for each medication bottle, as well as the entry of lot code and expiration date. 2D barcode scanning is accepted to facilitate this process and to allow for track and trace logging of each unique medication bottle as it passes through the facility. Upon completion of validating these scans, The product is poured into the canister's hopper under the surveillance of the pharmacy's security system, and a digital image is captured of the canister. The canister is then closed and physically secured with a zip tie. This also engages the electronic lock, which will automatically disengage if the canister door is opened at any point in the process following this step. The digital image taken during the filling process is presented to the pharmacist for approval. Once approved, the canister can then be placed onto a dispenser. And at that point, the software validates, again, the NDC assigned to the canister, the NDC assigned to the dispenser, ensuring that they match. The software also validates that the electronic seal is intact and that the contents of the canister have been verified by a pharmacist. Canister contents are then only released to the dispenser once these validations have occurred and once the dispenser is empty. This validation and release occurs solely under the software control with no human interaction. The replenishment process is combined with the automated dispensing process, where the dispenser counts and releases the medication into a pre-labeled patient-specific vial, images the contents for reference, and caps the vial also in a closed loop system. So again, there's no human interaction in that process. If deviation occurs at any point, the process is halted, all user screens are locked, automation units that are affected are disabled, and manual intervention by a pharmacist is required to clear and restart the process from the beginning. It is important to note that each action in this process is logged, providing end-to-end traceability. The production control software ensures that staff only have access to those tasks in which they are authorized to perform, while also logging who, when, and for which prescription, NDC, lot, and container an action was completed. It is also important to note that the software will never allow an action to occur if prior actions were not successfully completed. I hope that this information helps you understand how the software and hardware Walgreens is implementing enhances the overall quality of the prescription fulfillment process. And I'm happy to answer any technical questions you may have. Thank you.
Thank you.
Mr. President,
yes, go ahead.
May I ask a question? Is there anybody that looks at the final product for quality assurance to make sure the ink isn't too light or the tablets didn't get crushed in the vial? Does somebody look at it before it goes to the patient?
Yeah, so there are several processes that, when you think about ink smearing or something like that, the product themselves are scanned at the end of the process. So if there's any smudging on the label, there's barcodes on there that are scanned to detect any smearing of the ink. As far as looking in the vial after it is in that closed process, it's the process itself that ensures the quality. So the dispensing of the actual product detects broken tablets, into the canister itself, and then into the vial. So the visual inspection is really a less quality way of looking for broken tablets, maybe even at the bottom of the vial.
Okay. So, okay, I just want to make sure if, machines, you're right, don't make mistakes per se, but they do jam or, crush things, or the ink runs low, the ink is too high and it's too much. So you're assuring me that the final product that goes out is looked at or scanned or something where everything is perfect.
There is a visual inspection and a process along the entire way that ensures quality. And, the point I made earlier about 27 million of these last year being dispensed without a defect is a good stat to rely on.
Thank you, sir.
I have a question. Are you adding full sealed bottles when you're adding the drugs in?
Full sealed bottles, correctly. That's correct.
Okay. And then because looking at the picture on the canisters, it appears that they're kind of tall and deep. So how does the photo go to the pharmacist for the verification? If they're tall and deep, is it just looking from the top, or are they able to see all those pills that are put in?
Alicia, I don't know if you want to address anything related to pouring the canister in. Again, I'd refer back to there's two steps here. One is the process for quality. So the first thing is there's the drug itself is associated, the NDC is associated with a canister. And the system tells you, hey, use this canister. If you put the wrong canister on, it shuts the system down. If you open the wrong bottle and scan the wrong vial to pour it into the machine, and you're only doing one product at a time, if you scan the wrong vial, it shuts the machine down. The final visual inspection is validation that all of those steps took place, and it has the tablets that are located in the you can see on the actual canister down into the side of the canister as well as the top that it's poured in.
Okay, thank you.
And Mr. Cook, only a pharmacist would verify the final checkoff of the contents of the cell.
Yes, Mr. Lema.
Mr. Cook or Ms. Leisure, are the canister designed to fit a specific tablet? For example, famotidine from manufacturer A, if you switch to famotidine from manufacturer B, do you have to get a new canister or can the old canister work?
The canister itself is a carrier mechanism. So you can, a pharmacist can unassign generic A and reassign it to generic B, but they do have to go through that process for that to happen.
Thank you.
So it may work for multiple different products, but there's a switchover process where you have to reassociate it with just based on the functionality of the cassette, but you can't have two of them or switch them back and forth at any time. It has to very specifically be associated with one NDC at a time.
Board members, after reviewing it and looking at the presentation and understanding the science behind it, I can tell you that it is a system that is being used out there, and it is a system that, as presented today, is a safe system. And I do think it totally meets the definition of a technological deviation. And it'd be my opinion to support this, but I will open it up to a final discussion.
Mr. President, if I may add a question. As far as NIOSH products go, are you managing NIOSH products in this way as well? And any precautions being taken?
Yeah, it's interesting. NIOSH products, each one of these canisters is associated with an individual dispensing mechanism. So there's no cross-contamination of product whatsoever. Each canister is associated with an individual chute. There's not a common place where prescription medications are commingled. So it's safer than any other counting mechanism for NIOSH products.
So there would be, Mr. President, if I may, one more. As far as residue contamination, you're indicating that there would be none, as another tablet doesn't have the opportunity to come down the same chute?
That's exactly right.
Are the canisters going to be reused for different products? So if it's a NIOSH containing product and that canister is returned back to be reutilized for some other product, could there be another product that's placed in there?
Not without cleansing and the appropriate protocols, and likely once a canister is associated with an individual product, there's really no reason to change the product that's in that canister unless there's a new product that becomes available, or the prescriptions that you're dispensing, the mix of those changes. There's really no need to cycle out them and change the products that are associated with an individual canister.
To add to that, Matt, if you don't mind,
Please.
Once a medication of cross-contamination category that has a cross-contamination category is assigned to a canister or a dispenser, it can only ever be assigned to an NDC of the same cross-contamination category from there on out. So in those unlikely cases where they did want to switch a drug, it would have to remain in that cross-contamination category.
One more follow-up, Mr. President. Mm-hmm. So I would assume that you guys have policy procedures written around these things, these parameters, and the situation.
Yeah, absolutely. And those would be available upon inspection. Again, we're pending final inspection, and I would imagine that would be one of the items that would come up on that inspection.
Thank you.
Team, any other questions?
Just controlled substances, are you doing that through these machines?
C3 through 5s, but not C2s.
Is there any special record keeping that the machine does, or help you with that, if you could elaborate?
Yeah, it does. And Alicia, you could probably walk through this more specifically, but it does keep a perpetual inventory by canister. So we know how many we put in, we know how many came out, and there are processes that allow us to keep a perpetual inventory in those canisters.
Maintenance and cleaning of the machine, how often? Just a real brief statement on how often you're going to clean it, who's going to do it.
Yeah, there are protocols for cleaning in our SOPs, protocols for cleaning, and obviously that differs by type of tablet. Some are more frequently that may need to be done once a day, and some are once a week, right? Depending on the dust and particulate matter associated with each tablet. But those processes are all in place, and a technician will perform with the appropriate training. A technician will perform those functions in the facility.
Mr. President, I have a question for Mr. Cook. So, Mr. Cook, for the replenishment of the narcotics C3 to 5, only the pharmacists are performing that task, or the technician is also involved?
Initially, we have the intention of having the technician involved in that, and it will be done in a controlled cage. So to talk a bit about the safety protocols that we have in place, the barrier of the external of the building has badge access. There's also an additional badge access into the pharmacy itself, and then one more additional badge access into the control cage, where that process takes place. Within those, the kind of 3 layers of access to the controlled substances, this process will take place with very restricted access based on appropriate training and additional scrutiny with closed circuit television under the area. So very, very highly regulated as far as access and process. And then with addition of the perpetual inventory, any deviation from the expected quantity that is in the building will be very easily detected and could go back and be researched to help to hold any deviation, the person is responsible for that accountable.
So I'm more concerned with the actual mechanism of refilling the canisters. For example, if the canister runs empty for alprazolam, runs 1 milligram, runs empty, I'm gonna take a bottle from the safe of unopened bottle of 100 tablets of alprazolam 1 milligram. I'm gonna pour that into the canister, right? How would the machine know that I'm actually putting 100 rather than 99?
Yeah, it's a good point. First, there's an alert in the system based on the initial replenishment. So let's say we start day 1. I'm going to tell this canister I'm putting in, call it 300 tablets. So it's going to decrement based on the number of prescriptions that are filled, and keep track of that perpetually in the system. So it's going to alert me that, hey, you've only got 30 in here, but I have this other prescription for 60. Can you go get me some more out of the control cage, put them in here, and we also track that it has 30. I'm scanning a bottle of 100. I'm going to pour that bottle of 100 in. So now I have 130 in the system in that canister. If there's any deviation that we detect, for some reason the system thinks it can fill it, but it can't, and there's some deviation, it'll be very obvious that what was reported to have been put in that canister is not what was put in that canister, and we can investigate that immediately. So there are checks and balances that make sure that what we think is poured in that canister is what is actually poured in that canister.
So the unit can detect 99 tablets put in there versus 100 tablet put in there?
Well, not by weight, but over time, absolutely. So we'll know when the mechanism was actually filled, and if at any point when prescriptions are being dispensed over, let's say the course of the next couple of days, if a wrong quantity is detected, let's say we think we have 130 in there, but let's just walk through the scenario and address it directly. If you're thinking something like a technician took 30 of these tablets and put it in their pocket and left, right? We would know based on the fact that we're trying to dispense a prescription that we think we have those products in the canister, but that product is not in the canister. So it would be very easy for us to, as we're counting those tablets, to detect that the products are not in there. And then we could go back and look at the time that the canister was filled, look at the video and find out what happened. This technician said that they put 100 in the canister and it's not in there. And it would be very obvious on film what actually transpired during that transaction.
Okay.
Does that help?
That helps.
Thank you. Yeah, I am just as worried about that as you, and have reviewed it myself to make sure that the appropriate scrutiny is in place, and I feel very confident in the process.
I'm ready to make a motion.
Snare.
I would like to approve this request for deviation.
I will second.
Any other can I discussion?
Yes.
Usually when we approve deviations, we ask them to come back with a report in about 6 months or so and kind of update us on how things are going. Would this be appropriate in this case as well?
Yes.
In 6 months, how long will you have been using this technology?
Yeah, 6 months from now, if we are not in place until April or May, there may not be enough information to provide you at that time. We're happy to do it.
Maybe
but
6 months from go live.
6 months from go live.
Would that be appropriate to come back with a report of how things are proceeding, as we have done in the past with other deviations?
That's fine. Why don't we do 6 months from go live? It's more likely like January of next year, but that's fine.
Ms. Snare, would you like to amend your?
Yeah, I'm fine with adding that to my motion. Sure.
Okay, I'll amend my second. Having said that, all those in favor?
Aye. Aye.
Any opposed? Okay, thank you for your time today.
Thank you.
Thank you, board members.
Okay, future agenda items. I'll open it up for board discussion.
May I have one? May I submit one, sir?
Absolutely.
Based on kind of what we talked today about the grid, is it good to maybe add that to the agenda for next time? Let's look at it. It's been a couple of years since we've evaluated the grid. Let's look at it, make sure it's still fair and relevant. And then maybe we can make that a standing agenda item. Every year we look at, for example, election of officers or review of designee duties. Maybe we should review the grid every year to make sure it's appropriate for how the world is changing.
Okay. Any other items?
And then I have two issues that are for board staff. May I discuss those? This meeting, I had a little bit of difficulty. I probably my fault, but I did not get a Zoom invite to the meeting for today or yesterday. Is it possible to add the Zoom invite to Diligence so that right after the agenda or before the agenda or somewhere there's kind of the information for the Zoom meeting, it can be updated a couple of days before or whatever, and have the code for the Zoom meeting in Diligent?
Yes, I think we can figure something out as an attachment or something.
That'd be great. The second request I had is we seem to, we continue cases from one meeting to the next, but I put notes on my cases as things go along, but then the previous meeting's file gets deleted from Diligent and I can't go back and review my notes.
Yeah.
Is it possible to keep the previous meetings on Diligent for some period of time so that we have the opportunity to go back and refer to our notes from the previous meetings.
We'll check with our vendor if that's an option.
It would be helpful.
Switch to paper.
Yeah. That's all I had, Mr.
Mr. President, this is Kevin. I have an issue I want to raise to the board, and perhaps collectively as a board, we can come up with a suggestion for the future agenda. So about 3 weeks ago, I got a phone call from one of my physicians at work stating the fact that one of the pharmacists at CVS Pharmacy had refused to fill the C2 handwritten prescription for Norco for patient John Doe. And on the prescription, on the paper prescription, the physician from the ER did specifically write down system down. So evidently she couldn't e-scribe. So that's why she had to issue a written prescription. The patient, John Doe, brought it to CVS nearby, closer to his home. And the staff pharmacist told the patient that we're not going to fill this prescription. And the patient was in pain. So patient went back, called the physician called me, complained about pharmacy services. And I called the pharmacist at that particular store. And I told the pharmacist that at least during the COVID pandemic, pharmacists are allowed to fill paper C2 prescriptions, let alone system is down. So we allow them to do these kind of things during the pandemic. The staff pharmacist response to my comment, my statement was that according to my manager, pharmacy manager, we're not allowed to receive any written C2 prescriptions. So I informed Dr. Gandhi about the situation. And I said, this is poor customer service, number one. And number two, we're putting our patients at risk. These are the patients who came out of the ER in pain. In some cases, the pain can be excruciating. And our pharmacists out there just chose not to obey the guidelines set forth by the board. So I want to present this actual scenario to everyone on the board, just to gather ideas from my colleagues here on the board as to what should we do in these kind of scenarios to prevent more patients who are recently discharged from ER with control pain medications not having to go through these kind of experiences.
So Kim, could you put that on a future agenda?
I'll try to wordsmith it and we can discuss that further.
Yeah, I'll
Yes.
assist you.
Thank you, Dr. Gandhi. And I understand that we as pharmacists, we have the right to refuse to fill birth controls if it's against your religion and, you know, at the personal level. But if the board gives you the authority to fill C2 prescriptions, handwritten C2 prescriptions, then what is your concern? Why are you so adamant about not filling it? And who's suffering? The patients are suffering, not me, not the physician. At that time, I just called the physician back and I said, there's nothing
Mr.
we
Day,
can do.
I am afraid this item isn't on the agenda. So
Okay.
Cam has said, well, we will put it on a future agenda.
Thank you.
Thank you.
I have an item as well, Mr. President. This is just more of a request to ask maybe if Mr. Gandhi would consider putting our items that we've requested for future agendas on your report. That way we can kind of see where they're at in status. So maybe just keeping a running list and stating, like I said, like a status report, just so like I've had several questions and I just kind of hoping it'll show up again. And I don't know where certain things are at in the process.
Okay, anyone else?
Mr. President, outside of what I mentioned yesterday, and I believe we already have a pathway, creating a committee to look, task force to look forward at modernizing our rules. I think that's already moving forward, but want to make sure that's memorialized for the purposes of the minutes. Additionally, do we need, with the change in officers of the board, do we need to look at reassignment of committees in a future meeting, or do we wish to leave those the same? Complaint review, etc. Perhaps for discussion at the next meeting.
So typically the go forward has been to the chairs the complaint committee. Am I correct on that? Because that's what.
That is correct, Mr. President.
Okay. And Ms. Wamsley, as far as a topic here, what were you thinking?
I just didn't know if there was any appetite to change the committee moving forward, or if we were just going to move forward with that, and I'll replace you.
That would be the normal procedure, that
Okay.
if the chair switches, then a new chair would take over.
Okay, that's fine. Thank you.
I have a comment, not really a request, but I'm really grateful to the board staff for getting the book out early. I not only like to read it, but I like to have time to reflect on some of the issues, and getting it out early allows me to do that. And I think last couple of board meetings, they've done a really good job of getting the material out early. So thank you.
I agree. Thank you.
Thank you very much. Well-written summaries too, so great job to the staff.
Okay, with that, we will wrap up and do a call to the public.
Mr. President, we have no calls to the public.
Okay. All right. Thank you very much for a very productive meeting, and I wish you guys all the best, and we will see you here at the next meeting. This meeting is adjourned.
Bye, guys.
Bye. Thank you.
Thank you. Bye.
Excuse me. I'm so sorry. I must have missed something.
Ms. Reese, actually, your agenda item was already read, and your special request was approved.
Oh, I'm so sorry. I missed that. I've been trying to pay as close attention as I can. I apologize. Is there anything else I need to do?
No, you're good to go. Thank you.
I apologize. Thank you for your time.